My lord, two items. Item number 16. It's a motion matter where our lordship has fixed a connected matter tomorrow, 1840 of 2024. So this matter may come along with that matter. Item number 16. That eviction matter, my lord, Land Policy Act said.
Okay. And both sides are represented as the connected matter is.
We have taken consent for the other
On.
side. I think it is fixed tomorrow. Tomorrow it is.
On 2/5/2024, list this matter with on 2/4/2024.
My lord, one troubling your lordship, one matter. Item number 19,
Yes.
which is in the motion column. My lord, somehow there was some mistake in the first paragraph. The person is a proprietor, but he said that he representing but it's some mistake GST. So we want to withdraw it because that's a major problem. We want to withdraw this and file it. We have already made it ready, so 2 o'clock it may come up.
You can make corrections in the petition, if that is the only thing.
Nomenclature of the petition will get, that's the only.
Okay.
But I don't want to trouble your lordship. Let me
Okay.
correct it, and already it is corrected. It is, we are taking permission. It came at 2 o'clock, my lord. All remain the same.
Okay.
Everything remains the same.
Item 19. You want to withdraw it and file afresh?
I file afresh, and already is prepared. Everything is
Okay.
done at 2.
Both sides are represented. Mr. D. Das, Senior Counsel, assisted by Mr. D. Kalita, Counsel for the petitioner, submits that there is an inadvertent error in the cost title of this writ petition, and therefore he prays to permit the petitioner to withdraw the same and to file again.
My lord, again we file. Everything is ready. 2
There
o'clock
is-
where this matter comes.
Here is allowed. Matter stands dismissed and withdrawn with liberty to approach again.
Yes, it may come at 2 o'clock.
You have to give a mention memo.
Yes, we have given our mention. That will be allowed. Mention 2 o'clock.
Okay, 2 o'clock.
Tender is the last day tomorrow.
Okay.
That's why. I'm deeply aware.
May it please your lordship. Lordship, consent from the other party, I beg to mention item number 31 for adjournment, lordship.
Okay. Your for
Respondent number 124. Corporation
number 1.
124.
Okay. Concern of the other side. Miss,
Amison. Amison.
speak loudly. Counsel for respondent number 1, prays for adjournment, prayer is allowed. List after,
Next week, lordship. Next week, any day, lordship.
list after week. And the interim order is operating?
No, lordship. No, lordship.
Okay. Yes.
Please, your lordship. Your lordship, I'd like to mention 2 items for listing. One is for
Listing due to the court.
withdrawal, your lordship, and another for
Give to the court master, or prays for listing, give to the court master.
high level.
I have a clear for unlisted motion today itself, madam. The matter pertains to eviction proceeding of the petitioner's shop, madam, that the petitioner is running a grocery shop in the Hatshimari market, madam, in front of the DC office.
Okay.
The suddenly, madam, without prior notice, without any notice, madam, the circle officer and the staffs, madam, they came with bulldozer
Permitted.
today itself, madam.
Petitioner, lordship.
Nazma. Already numbered, madam. Petition has
Ensure
been
that
numbered.
copies are served on the government
Yes,
advocate.
yes, madam, already case has been numbered, madam.
Daily list item 1 for motion.
None appears on call for the petitioner. You should notice return of it in 4 weeks.
Yeah, I think so.
For revenue will be there, Mr. A. Bhattacharya, standing counsel for Revenue Department accepts notice on behalf of respondent number one, and Mrs. Sharna Lanet. Government advocate accepts notice for respondent number 2 and 3. Stop. Extra copies of the petition, the formal issuance of formal notice is dispensed with. However, extra copies of the petition will be served on them within 2 days. Next, the dependency of the petition shall not be a bar for the concerned respondent authorities to look into the grievance of the petition.
Item 2,
Same one.
item 3,
Matt, please allow.
Just,
Hearing,
just. a minute. You see, the activity is going on, which is which is contrary to law. What prevents you from filing a FIR? You file a representation, you go to superintendent of police, but you are not filing an FIR. Why?
Lordship, page 25 and 26 kindly have a look here.
25, 26.
Yes, public submitted complaint, your lordship, thereafter these two letters.
No, this
were
complaint,
issued.
25 complaints, what prevents you from going to the police? You don't file an FIR, you go to the superintendent of police, nothing will happen. And what strikes the eye is that your pleading is that he is occupying a government land. So therefore, you are more interested in the land rather than
No,
the activities.
No, no. But the question is that your lordship, the place where he is carrying the business is only 100 kilometer far away from the, 100 meter far away from the office of the deputy commissioner and some other office.
No, you
Because
file an FIR.
the
You
Hatshimari is
close
the
this
dis-
petition, you go and file an FIR if there is a illegal activity going on. Nothing prevents you from going to the police. Because this is otherwise a cognizable offense. We won't entertain a writ petition here. If it is slaughtering cow, it's a offense, prescribed offense.
But regarding this, your lordship, we made complaint before the superintendent of police also.
So correct, tomorrow
They
there will be,
also, on
no,
the
no, I
basis of
understand.
that,
Tomorrow there will be a pickpocket in the bus, in the city bus where I am traveling. So I go to the High Court and file a writ petition.
admittedly that, your lordship, but we have already approached before the superintendent of police. The police can take also the action, your lordship, but they are,
Superintendent of Police is not the authority to receive an FIR.
But
It's a-
at this stage, your lordship, I am seeking, since page 25 and 26, these two letters were issued and they have not done anything. So I am praying your lordship for issuing notice and may direct them what action they have taken in response to that two letters.
No, not a repetition. But Mr. A.M. Khan, learned counsel for the petitioners, and Mrs. S. Sharma, learned government advocate, appearing for the
All the
respondents. Next paragraph. The petitioner projects that he is a public spirited person and he has submitted a complaint
Oh, nice.
against an illegal abattoir. ABATOIR, just let me check this spelling, abattoir, ABATOIR. Where cow slaughtering is allegedly being done. Full stop. As the complaint of the petitioner before the district commissioner and the superintendent of police of South Salmana Mankachar did not yield any fruit, the present writ petition has been filed under Article 226 of the Constitution of India. Full stop. Next paragraph. If an illegal cow slaughtering is being carried out, it is a cognizable offense under the Assam Cattle, what is the act name?
Assam Cattle,
Assam Cattle?
Let's pass.
No, not
Assam
trespass.
Cattle Preservation Act 2021.
Reservation
Act
Act 2021.
21.
Full stop. Therefore, nothing prevents the petitioner to approach the jurisdictional police station, lodge an FIR. Full stop. Next slide. There is another reason for not entertaining the writ petition, which is the fact that the concerned person against whom complaint is alleged is not arrayed as a party. Full stop. Therefore,
No, he has been made party, your lordship.
where?
Respondent number 6.
Respond number?
6. Initially, he was not
Oh,
made
6.
party, but
Okay, no, don't say that. Okay, then this next one. Therefore, as the petitioner has an alternative remedy to approach the jurisdictional police station, the writ petition is not entertained and the same is dismissed.
but one thing your lordship may reflect your lordship that we have already approached before the superintendent of police.
I have written, you
Because
don't
in
hear
para
the
11
dictation. Your problem is that you don't hear the dictation.
Item 4.
May I please, your lordship.
Yes.
Lordship, on last occasion, lordship, instruction was sought from the department, lordship, whether the written bench is going to be instituted.
Yes, what has happened? Board of Revenue is functioning or not?
Items are not for them.
I have intimated Mr. Nath, my lord, last time, last
Okay.
occasion he was
Okay,
appeared,
okay.
maybe.
After some
maybe
time.
After some time.
Item 5.
Took some time.
With pleasure, Lordship. Lordship, matter may be passed on for the day, my lord. My lord, my senior is annual, my lord.
Just a moment. You amend your writ petition and give us the details of what is wrong, what is right. This is not a interpretation, this exercise will not do. To read the brief, find out which is your bank account number, compare it with the documents you have submitted. If you don't do this in the right manner, we dismiss your writ petition.
My lord.
I am
according
not,
to-
I am not supposed to find things in your writ petition. You say that your account number you gave was wrong. What is wrong and what is right? Shows from your writ petition. Now you want us to find out. I'll read the entire documents, as that is the only work I have, to read all the documents, to find out, to make notes, then find out, compare it, and then come to court and then deliver orders for you. This is how do you prepare a writ petition?
My lord, according to the official authorized, my lord.
Please,
bank
I
details-
give you 1 minute time. Tell me the account numbers, two comparative account numbers, wrong and right. I give you 1 minute. Find it out. So you see, it's very difficult to read. You don't even have the energy to fold papers and to find out. We dismiss
My
the
lord.
writ petition, you file it again.
My lord, bank details are wrong.
What is wrong?
My
I'm
lord,
asking you for the
petition
third
again
time.
Submitted, my lord.
Very good, submit it. Wait. In our home, when we are in trouble, we come before the photograph of a god and pray.
My lord.
You do the same thing. What is wrong in making a prayer before the god? Whomever you have faith.
My lord, I have instruction collected from the
Ah.
respondent, my lord. They have already two petitioners,
No, we
my
are
lord.
dismissing it. You comment. I don't have the energy to be wasted. Your name?
Arrived, my lord.
Or Mr. R.I. Bhunyadan, counsel for the petitioner, appearing on instructions of Mr. N.H. Mazhabia, counsel for the petitioners. Also, Mrs. Sumitra Saikia, as Sharma, and government advocate appearing for all the respondents. All the respondents?
Not all the respondents. Respondent 2 and 3 minutes.
Respondent numbers 2 and 3. Acha, and Mrs. P.R. Mohanty and standing counsel for the Revenue Department appearing for respondent number 1. Next, the petitioners have projected that they are the beneficiaries of money sanctioned against flood damage suffered by them. Full stop. The compensation was to be deposited in their bank account. Full stop. However, it is projected that the petitioners had given incorrect bank details to the concerned field staff of the Revenue Department. And although the petitioners have approached the authorities, the compensation was not deposited in their accounts. Full stop. Next paragraph. In this writ petition, 19 writ petitioners have joined. Full stop. There is no statement as to the details of the bank accounts in respect of each of the petitioners. Full stop. Therefore, even to prima facie satisfy, to be prima facie satisfied, the pleadings are not there in the writ petition. Full stop. Therefore, the court cannot be expected to read the appended documents and then find out what is what was wrong, what was the wrong account number, or what is the correct account number. Full stop. Under such circumstances, the court is disinclined to entertain this writ petition, which is which does not have appropriate pleadings. Full stop. The writ petition stands dismissed. Next paragraph. However, the petitioners are at liberty to approach the court again by
My lord,
making appropriate pleadings.
My senior is unwell, my lord. Only for.
He may be
today, my lord.
unwell, but we are not entertaining this repetition. I don't have that much of time. The amount of time I spent in reading the brief is my personal time. After you have to just stand outside at 7:30 in the evening and find me going out. That is the time I go out. Then I go home by the time all files are there. Then I spend my private time.
My lord, large sense, my lord.
No. Incompetent pleadings we are not entertaining. I don't have that much of time. You are fortunate we are not imposing cost. Any time spent more will entail cost, which will be recovered from the council, not from the petitioner. Therefore, please, you allow the next person to come in. Item 6. Yes.
In this case, the instruction was short for lordship.
Correct. I have received instruction.
No, look at paragraph 2.
My lord.
Put on.
Number.
And last page.
Lordship.
And there's one more thing. You come to second last page. Now, in fact, what is happening, I don't know. The assessment of the cost of your land and building is 15 lakh.
He has
The
received.
assessment of your land and building is 15 lakh. They're giving you compensation of 52.64 lakh.
Lordship, I have this one for Assam type building, perhaps.
Everything is here.
Lordship.
If they are saying about the plinth beam is RCC as per design,
In para 5 of the repetition, my lord, he has also admitted the same.
I have admitted that I have received the
Has
amount.
received.
just an agreement amount.
After signing that, my humble submission is, my lord, after signing that Form B, this
Close
process
this
is,
petition.
Oh.
If you have anything, you will have to
then he has
go
to
to
go
the
to civil
appropriate
court,
authority.
appropriate civil.
Let Mr. R. Mukund, counsel for the petitioner. And Mrs. M. Burma, Ms. M. Burma, and the government advocate appearing for all the respondents.
My lord.
No, for respondent numbers 1 to 4.
2, 3, 4, my lord, I am
So
appearing.
2, 3, 4. Will be for 1.
Revenue.
Revenue is, this is for number 1. Will be first. Will be first. Agreed by the quantum of compensation assessed in respect of land and house of the petitioner under ASOM Mala MALA project, the petitioner has submitted representations on the ground that while acquiring his land, no compensation was paid in respect of the shop which was situated therein. Hence, this writ petition has been filed in Article 226 of the Constitution of India. Next paragraph. The learned government advocate has produced a copy of instructions from the District Commissioner Lakhimpur by communication dated 30/4/2024, wherein it is projected that the assessment of the land and structures standing thereon has been assessed and verified in presence of the petitioner by the junior engineer, Public Works Department within bracket building from Lakhimpur. And that the value of the shop has been assessed at rupees 5,52,591. Sorry, residence. And the valuation of the shop was made at rupees 5,52,591. And the valuation of the building was assessed at rupees 15,38,679. Full stop. Pursuant to such valuation, the petitioner has entered into an agreement with the executive engineer PWRD, who is the Lakhimpur, who is the requisitioning agency, and has agreed to accept a total compensation of rupees 52,64,837.60, which is dated 30 March 2022. The next part is said instructions are made a part of record. Next part, in view of the agreement between the requisitioning authority and the petitioner, as referred above. Comma. This repetition would not be maintainable. And therefore this repetition stands closed. First, however, liberty is granted to the petitioner to take such measures as he may be alternatively permitted in accordance with law.
So at this stage, may I pray one thing, Lords? So as per clause 4.14 of the notification, the deputy commissioner shall made an award according to the terms of the such agreements, Lordship. If such award has been passed, Lordship, that may be given to the petitioner, Lordship.
Okay. So this order shall not be a bar for the concerned responding authorities to release compensation amount to the petitioner.
Obliged.
Okay.
Obliged.
Item 7.
May please, Your Lordship. My limited prayer is that, Your Lordship, the mother of the petitioner, which is the respondent number 7, is an old lady and is mentally ill, Your Lordship. She is the owner of a plot of land which she has inherited by annexure 1, Your Lordship.
Please tell
And
us.
accordingly-
Please, just a moment. Please tell us here in the state, we have an act for elderly people, for care of elderly people.
Yes.
What is the name of the act?
Doesn't 17 Act is there.
It's okay, you take your time. You don't have to stand here to do it. You take your time and get me.
Maintenance of welfare and parents, welfare of parents and senior citizens.
There is an act, but since I have stopped reading, I will not remember.
Maintenance and welfare of parents and senior
Please,
citizens.
please be
Act,
slow.
Madam.
Please be slow. Please be slow.
I'm sorry.
Hmm.
Maintenance and welfare of parents and senior.
Just a
citizens-
moment.
Maintenance and welfare of parents.
And
Senior Citizens Act 2007.
Senior Citizen
Citizens Act 2007.
Act 2000.
And there's a set of rules under that Act 2012.
Already tribunal is already there, Lord. May I
That's fine.
please-
That's fine. Huh,
This is,
Oh, very good.
so they have to approach the tribunal.
No, good.
All the district just courts have been.
You were armed. I did not know that. Very good. It's an old movie where the catchword was Mugambo Khushwa. So you have to go there. We can't do anything more.
That can be done, Your Lordship. I will do it. My only limited prayer was let the deputy commissioner grant NOC, but before granting NOC, my limited prayer is to assess the mental condition of our mother as respondent.
No, you see, we can't have that presumption. The reason is you see the Mental Health Act, which is repealed, and thereafter what do you call this? What is the new act? Mental
Health care.
Healthcare Act, huh? In Mental Healthcare Act, there's a procedure prescribed. You just can't, the court can't make a presumption that somebody is mentally ill.
No, I am not praying for drawing, drawal
No,
of
no, but
presumption, Your
you see,
Lordship.
what is.
That can be done only by the medical board, Your Lordship.
You go there, they are empowered to do it. If the mental condition is not correct, the court can't have a presumption.
Yes.
Under the erstwhile Mental Health Act, it was the civil surgeon who would have done it for a district. Now there are authorities and they have to be mandatorily sent there, have an assessment made, then only they can be said to be
Yes, yes, I can-
mentally.
I can do so, Your
Court-
Lordship. My only apprehension is that in the meantime,
No, it may be
the
anywhere.
sale
You see,
NOC may be
Mr.
granted.
Masumdar, I'm just presuming, I have not heard it, but I am presuming.
Yes,
Supposing I pass a order adverse to your interest, maybe you may go out and say that, oh, he is mentally unsound.
no, Your Lordship.
No, I don't know.
I
I'm just
have a hope
presuming.
that Your
I'm not
Lordship
saying
will
it.
delay
I'm not blaming
what
you,
is
but
the
I'm saying
prescribed
it.
procedure of law. I
No,
have
but
that faith, Your Lordship.
that will not call for an inquiry.
I have that faith. I have that faith,
No.
faith and belief, to Your Lordship.
Uh.
Whatever Your Lordship, I will approach the appropriate authority only.
You
My
may
only
apply.
apprehension is that it is
You
a
may find
parent
Not
property
in a writ petition.
and only at the
Because-
instigation of the, why, with
No,
whom
in a writ
there is a
petition,
domestic violence.
in a writ petition, we are not empowered. You show us any decision anywhere. Any country, any court in the country, where out of presumption that somebody is mentally unsound, an inquiry can be ordered in a writ court.
I'm not
You
paying
show us
for
anything.
actually inquiry, Your Lordship.
At least yesterday I
Only
did not,
to assess her mental condition.
at least I did not find it. Yesterday I did not find it. My research time is very limited.
Yes, yes.
I did not find it. That's why we are asking you. If I have not found it, you will have to assist us to
Yes.
show that there is any decision in the country where just because of apprehension, mental assessment of a person can be done. Because then I stand at a risk. 50% of the people going out may have an apprehension about my mental instability.
Meet her
I
next,
don't know.
next week.
I
Your
can't
Lordship.
risk,
will
I can't
go
risk my
through-
career just because of that.
My lord, there is a decision of the appeals court that on apprehension, my lord, the court will not pass an
Yes.
order.
No, that is different, not for mental.
My lord, even it's an apprehension, my lord,
That's
what
okay.
they are saying,
But I'm on specific.
my lord.
Because yesterday on the basis of mental healthcare, I tried to find out, I did not get one.
Yes.
Where it says that somebody may allege that he is mentally unsound, and then the red court will issue a direction because because in the trial it is otherwise.
Yes.
300, what is the provision? CRPC, if the deposition of a person is not in the language of the court, then, or the court, when it's recording the demeanor of a witness, finds that he is mentally unsound, then he will be subjected to a mental assessment.
That's in a trial, my lord.
So we can't, I don't have, I can't say. So we close it, we permit you to go there. Mr. R. Mazumdar, learned counsel for the petitioner. Mrs. P. R. Mahanto, learned standing counsel for the revenue department, preparing for respondent number 1. Mrs. Mr. Lata, I'm sorry, I did not hear you. You may be supporting him.
No, I am not supporting.
No, okay. But I have to hear you, that's why.
I am for respondent number
Okay.
6, my lord. Municipal board.
Okay.
2,
This
3.
is S. Sharma, and government advocate appearing for respondent number 2, 3, 4, 5. And Mr. S. Datta, and senior counsel assisted by Mr. S. Datta, counsel for respondent number 6. So in your order proposed to be passed, comma. Issuance of notice. No, don't add that. Next paragraph. The case of the petitioner is that the mother, who is arrayed as respondent number 7, is aged about 78 years and is suffering from various old age ailments, including neurological problems, Full stop. It is projected that she is unable to speak, read or write and is incapable of giving her free consent. Full stop. It appears from the statements made in this writ petition that there is a family dispute between the petitioners and the respondent number 8. And it is projected that that their mother is presently residing with respondent numbers 8 and 9. And that the respondent number 8 is not permitting the petitioners to meet their mother. Full stop. Next para. It is projected that a land sale permission has been applied for in respect of the property which is in the name of respondent number 7. And although objection was filed by the petitioners, comma, the additional district commissioner within bracket revenue branch, comma, Sadar, comma, NOC section bracket closed, Silchar, had rejected the objection by order dated 18/1/2024. They said order has been assailed in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. The brief facts as narrated above discloses existence of disputed questions of fact. And it appears that there is dispute with the members of the family. Full stop. Under such circumstances, comma, the court is disinclined to entertain this writ petition, as the parties have an alternative remedy, as the petitioners have an alternative remedy of approaching the civil court. Next paragraph. The learned counsel for the petitioners have submitted that at least the court can issue a direction for assessment of the mental health of respondent number 7. Full stop. In this regard, the court is of the considered opinion that the materials available in the writ petition are insufficient for the court to prima facie record its satisfaction that an inquiry is required to assess the mental health of respondent number 7. Full stop. If the petitioners have any apprehension of that nature, comma, the petitioners may be well advised to approach the competent authority under the Maintenance of Welfare of Parents and Senior Citizens Act, 2007, Full stop. The learned government advocate has submitted upon instructions that under section 7 within bracket capital I of the provisions of the said act, comma, a maintenance tribunal and appellate tribunal has been notified by the government of Assam by notifications issued on 2/8/2008, and that the district social welfare officers in the state of Assam have been notified as maintenance officers by notification dated 2/8/2008. Full stop. If so advised, the petitioners shall expose as to whether they desire to avail remedy as provided under the said aforesaid act. Full stop. The aforesaid observations, this petition stands closed. Obligation and liberty. The petition stands closed.
Published.
You see, there is another reason why we could have not entertained this writ petition. Although it's too technical, but there are two reasons, not one, two reasons. You see, when it comes to a family dispute, under the CPC, we have a provision where family disputes must mandatorily be referred to mediation. This one. Second is that you yourself claim that your mother is mentally unsound. And you have made this in the writ petition, respondent number 7 is not represented by any next friend. Therefore, even under the CPC,
Guardian.
we have the power to dismiss it unless you have the mother represented to a
By-
next friend.
It will,
So we otherwise would have been, it could have been dismissed otherwise in the
there you
Your lordship will find the affidavit is by one of the petitioner and the respondent number 7. I don't know how it is.
Oh, is it? This I did not see.
That, my lord, it struck me, my lord. Anyway, my lord, I have learned one thing, this maintenance of this welfare, the Senior Citizen Act. My lord, that will help us in many ways.
Yes, we must be informed.
In
That's
regard
the
to
only thing.
family matters also, my lord.
We must only be informed.
Yes, yes.
This,
I also came to know.
Obliged.
The only fact is that I have no custody of the medical papers,
Huh?
your lordship. I have no custody of the medical papers. They are already with the respondent number 8. So civil dispute, I cannot show the, to
No, I
prove
don't
our
know.
mental
I
condition, your
don't know.
lordship. I am handicapped by that,
I don't know.
your lordship.
You'll have to just.
Whether the
Uh,
tribunal can go through this,
No,
I
not
will
that. In a-
explore your
in
lordship.
in a lighter tone. If I missed out someone, you may excuse me, but 1, 2, 3 senior lawyers are there.
Yes. I will go through the act, your lordship. Whether
Or
these
take their
issue can
advice,
be explored.
or take their advice.
I will definitely take the advice of my
Obliged.
senior friend,
Yes,
your
Dr.
lordship.
Mr. Saraf, your item 8.
So this is one, that extension notification matter lordship.
Okay.
Again, a similar matter. I have provided a copy of order lordship,
Yes.
similar.
Then it's
The order date needs to be changed lordship.
order date. Okay.
Paragraph 7,
Paragraph 7, order date.
28/3/2024.
Okay.
And the paragraph 4 needs to be omitted lordship.
Paragraph 4 is to be omitted. Okay. Same order.
Your lordship, I'll be representing only respondent number 2.
Respond number 2.
Yes.
I am 3 to 6.
Acha, just numbers will be changed. Huh? For government, Ms. K. Fukan. Respondent number one, Mr. Chaudhary, you are for only two,
Yes, madam.
and Mr. Kyal,
3 to 6.
three to six. Okay, there are no other.
One.
One, I have recorded her name. So, when do you fix these matters?
After 4 weeks. In the meantime, we have received instruction.
Because here we have given the date of 10/5. We give the same date or different date?
Same date.
Same date. Okay, 10/5. Same.
My lordship.
Item 9.
But Mr. Sharma, thank you for this. I'm in fact amazed that you are so prepared.
No, Lordship, most probably about a month ago, Lordship, similar case was on that day, accordingly, Lordship,
No,
I have
still-
obtained that instructions
still
and
to
I
be
kept one copy there,
Still
Lordship.
to be armed with that notification is something very wonderful. Thank you.
So good.
Yes, just a moment. Yes, mining.
Mining. First of all, this director of the geology and mining, he doesn't have the power to issue any permit or pass in respect of the items those are mentioned in Schedule Y. Schedule, he is only can issue permit under the Schedule Acts. Now here the ordinarily for the purpose of road construction, etc., this falls in Schedule Y, so he doesn't have the power. We have been making a complaint. All these petitioners are
No, there's a special provision for ongoing contracts. They have got power.
Rule 5, Your Lordship.
Rule 5,
Rule 5.
they have got power. You can only issue a notice to examine the matter, but we can't give an interim order because this is something we have dealt with earlier. Or under Rule 5.
Here, thing is that district administration has taken note of it, my lord. District administration has taken note of it, and the permit that has been issued in respect of Josimili area. The district administration said don't keep it in abeyance because joint verification is necessary. Then, my lord, without having any mining plan afresh, my lord, the director just changed the name from Josimili to my lord Kasadia, my lord, and issued another permit in the respondent number 9. Now, my lord, under the this approval also, the plan also, the forest clearance is necessary, and immediately we have complained. Then, my lord, the water resource department has said don't issue to the forest department, don't issue NOC. So the NOC has not been issued. Now the third option the director is doing, he is allowing the extraction by way of issued transit chalan. That is not the mining pass.
Where is that?
That is your lordship will find at page 102. This is the only document available with them for the purpose of extraction. This is a transit chalan which are issued by the leaseholders. Mining leaseholders issues for
Just a moment.
transportation of the
102.
102. Before that, at page 90, lordship, can you see?
90.
Page 90. It is the
Just a moment. Just a moment.
district administration and the authority which who are responsible for protection of the dikes and all these things, they are in favor of maintaining the this siltation there. They don't want any mining thereof. Because that will affect the protection that which has been constructed in 2010. And this Rule 5 does not empower the Director of Geology to issue permit in respect of the Civil the articles.
Please come to that
Yes.
provision. Which page?
Lordship, may first come to the Rule 3.
Page.
248.
This book page.
Oh, yes, madam.
248.
248. 248. Power to grant mining lease or mining contract or any other concession or license or transit pass or permit, etc. A mining lease or a mining contract or permit or any other concession or license or transit pass or permit or license or control or regulation of mining or other action under these rules shall be granted taken by the director in respect of minor minerals for industrial and specific use as specified in Civil Acts. The principal chief conservator of forest and a head of forest,
You're reading where?
page 248, Rule 3.
Rule 3.
Page 248.
Yes.
So, the director is empowered only in respect of industrial and specific uses as specified in Civil Acts. And the principal chief conservator in respect of Y, my lord. Now, this Civil Acts and Y. At page 361.
Yes.
Serial number 10, my lord, page 361, that is Civil Acts. When used in cement manufacturing or in any industry other than cottage industry. Only while the permit is used in respect for the use of the ordinarily in respect of cement manufacturing and other industry purpose other than cottage, then my lord, the Director of Geology can. Now your lordship will come to the next Civil Y, page 363. Serial number 3, Civil Y. Serial number 2, my lord. Other than used in cement manufacturing or in any industry except cottage industry. So that is the principal chief conservator of forest who can the issue
No, that
permit.
is ordinary clay.
Ordinary clay. Ordinary clay.
What is?
The permit is for, my lord. Permit has been issued, my lord, will find page 38. Approval of mining plan along with progressive mine closure plan in respect of Joshi Mill, Tapa Pathar, ordinary clay mining permit area at Joshi Mill. So this plan is also for Joshi Mill, Tapa Pathar area, this mining plan. not for any other place. Your lordship may have a condition, my lord.
Just a moment. This is in whose favor?
Hmm?
This is in whose favor?
9, respondent number 9,
Respondent number 9.
respondent number 9. This has been kept in abeyance by the, my lord, district administration. Then what he has done, my lord, the director.
Where is that?
Yes, ma'am. That your lordship, 77, my lord. The last, my lord, paragraph, in view of the above.
Just a page number.
Page number 77.
Yes.
And lordship, similarly, second last paragraph, in view of the above, it appears that a joint verification has become essential at this stage by the circle officer, Government Revenue Circle and Water Resource Department before the actual mining starts, and until then it may be kept in abeyance. So now the director has done, my lord. We'll find at page 87. He has just changed the place from Josimili to, my lord, Kachardia. There was no mining plan for the, my lord, this permit in Kasardia. It is the same permit, my lord, the plan that was for Josimili area.
Page number.
Page number 87. Simply change the, my lord, village name without there being any mining plan, which is a condition precedent under the rule 48 and 52 of the rules.
Yes.
And strangely, my lord, will once come to the, my lord, the first one, my lord. Page 70, before my lord, proceeding further, my lord, page 70, your lordship will find, my lord.
70.
Page 70. This is the first one that was issued, and thereafter it was kept in abeyance. So he has issued the, my lord, changed the name Josimili into Koseadia. And very interestingly, your lordship will kindly see, my lord, page 71.
Is 71.
page 71. The purpose for which that mining plan had been issued. It's mentioned, my lord, the last paragraph, serial number 1, page 71.
Yes.
Construction of road cum embankment of B dike from Josimili to Nagarbera from so and so, so and so. It is the construction work. Now, in the new permit that approval has been given, my lord, at page 87, relevant at page 88. Second last paragraph. Construction of road cum embankment of B dike from Kachardia Pathar to Nagarbera. Just the word Kachardia has also been changed. This is the walk, which is supposed to be under execution, but my instruction, no road exists, my lord, either by this name or the name, my lord, mentioned in the earlier permit, my lord. Only the change the name plan is the same for Josimili. And even the construction, my lord, that also, my lord, the other one, it is appearing Josimili. So here they have changed it to Kachardia Pathar. Now this has again, my lord, the authority after being complained, my lord, at page 90. Water Resource Department says that.
That's wrong.
Lordship.
Yes, after page 88.
Page 91. With reference to the subject cited above, I have the honor to inform you that as per the field verification report provided by Assistant Executive Engineer Soigam Boko Subdivision, the GPS coordinate for collection and extraction of river silt ordinary clay from Brahmaputra River at village Kasiadia Pathar at the location so and so, which is only 6 to 6 m away from the bank, where ADB tier protection measure is existing, as a result of which any extraction work on the mentioned location will further cause erosion, resulting in deterioration of the existing work. Under the circumstances, MOC on that location may not be provided, subject to finding of a new location far from the bank of river Brahmaputra, such that the existing ADB tier 2 work and river bank stability is not affected. Well, under the approval, the forest clearance is
Yes,
environmental.
executive engineer is also a knowledgeable man.
Hello?
His knowledge is also exemplary. To collect river sand from far away from river. Very good.
Because protection dike is there at that.
I understand, but
he's
the language
nearby
is,
the
language is that you collect river clay from far away from the river. Intelligent man.
because the plan also provides 100 meters away from the river stream. That is also there.
It's okay. I'm not assessing.
Now,
I'm only-
the third mode, this is the second attempt he has failed. The third attempt, what he is doing, my lord, he had issued this challan, transit challan at page 102.
Okay.
And on that strength, the persons are, my lord, collecting.
Okay.
At page 102. This is only in respect of the leaseholder issues this this transit challenge for transportation of the clay. It doesn't
Yes.
authorize the mining, etc.
Yes.
At page 102, it is issued by the Director of Geology and Mining, Your Lordship. So the Director in Geology and Mining has to come and say on what basis they issued this. In fact, a joint verification report is still pending, Your Lordship, like 114, Your Lordship. The circle officer has already communicated DFO, and a joint verification is to be scheduled on 7/2/2024.
Yes.
So this joint verification report, I'd like to bring this joint verification to the court, Your Lordship. The status of the joint verification report. And far as this transit challenge is concerned, Your Lordship, this issued by the Director of Geology and Mining. So Department of Geology and Mining has to come and say, and the price is on what basis they have issued this challenge, Your Lordship.
Who's appealing for them?
Lordship, issue notice, my lord, I'll obtain instructions.
But there has to be this has to be stayed. But Mr. P.G. Saikia, and Senior Counsel, assisted by Mr. A. Ali, Counsel for the petitioner. Petitioners. Also heard. This is S. Sharma, Government Advocate, appearing for respondent number 1,
1, 2, 4,
Two.
6, 7, and 8, my lord.
4, 6, 7, and 8. And Mr. R. R. Gogoil, and Standing Counsel for the Forest Department, appearing for respondent number 3. Next one. By filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed transit challan dated 16/4/2024, issued by the Director of Geology and Mining Department, Government of Assam, within bracket respondent number 2. Transit challan within bracket annexure 15.
And also the approval of mining plans.
Huh? Where is that?
Approval of the mining plans, my lord. Page 87, my lord. That is also challenged. Then the first one also is under challenge. Page 38.
As well as letter dated 14/2/2024 within bracket annexure 12, which extension was granted. Comma. Lecture 7, which is this page?
Annexure 7, my lord, page 17. 70.
Okay, letter dated 28/12/2023 within bracket Annexure 7, allowing respondent time to remove public extract ordinary clay public silt from river Brahmaputra at village Kashiar, Kachiar, Diya is Pathar. Make it serially, huh? 28, Annexure 7 will be first. Annexure 12, second, Annexure 14, third. Full stop. The said communications are in favor of respondent numbers
9.
7,
9.
like 9, okay, respondent number 9. Next one. Is projected that the extractions permitted by the Director of Geology and Mining, Assam, is on the basis of mining plan which was approved by the competent authority on 15/12/2023. Full stop. However, the initial approval granted for mining on 28/12/2023 was kept in abeyance by the additional deputy commissioner, the additional district commissioner within bracket Kamrup, by order dated 2/1/2024. Full stop. Thereafter, the Director, Geology and Mining, by another communication dated 14/2/2023, only altered the name of the village from JORSHIMLI, Joshimli, TO2. What is that name?
Kasari Diya Pathar.
Kasedi Dia. I don't know. That's right. Without any alteration in the mining plan. That's right. The distance between the two villages is said to be 600. How many meters?
These are contiguous, my lord.
These are
640.
some area was given somewhere.
Page 90, your lordship.
What is it?
626 meters.
626 meter, page 90.
90, yes. Annexure 30.
No, 626 is from this bank. What is the distance between these two villages?
These are contiguous.
Huh?
These are contiguous villages.
Acha.
Petitioners are belonging to both the villages.
The senior counsel for the petitioners submit that the two villages are contiguous. So it is further submitted that the executive engineer, Kamrup Rural Water Resources Subdivision, had written to the divisional forest officer from Kamrup West Division expressing
Page 90.
apprehension that as the collection area is only 6 to 6 meters away from the river bank, where capital ADB. Next word is T, capital T small r, dash Roman 2. Protection measures is existing, comma, extraction works would cause erosion and will result in deterioration of the existing works. Full stop. Thereafter, it is projected that thereafter, the Director of Geology and Mining Assam has started issuing transit challan favoring respondent number 7, permitting, lesser 9. Full stop. Accordingly, it is submitted that without any approved mining lease or contract, comma, the respondent number 9 is being permitted to extract silt oblique clay, river silt oblique clay, and to transport them despite objections by the district administration by letter dated 2/1/2024 and by the Water Resources Department by letter dated 19/2/2024. Next paragraph. Issue notice of motion returnable on fifth date after 4 weeks. Returnable on so and so. As the Learned State and Departmental Council have accepted notice, voting issuance of formal notice is dispensed with. However, extra copies of the writ petition will be served on them in course of the day. Next, the petitioners shall take steps within 2 days for service of notice on the respondent numbers 9 to 13 by registered post with AD, which is made returnable on so and so. Full stop. The counsel for the petitioner is permitted to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next paragraph. In view of so you should notice on the behalf of maintenance also. Notice including notice and payable. Next paragraph. In view of communication dated 19/2/2024 by the executive engineer, Kamrup River WR subdivision, within bracket annexure 13, and noted by the communication by the additional deputy district commissioner, Kamrup, letter dated 2/1/2024. The court is inclined to direct the Directorate of Geology and Mining Assam. to forthwith stop ongoing extraction and collection of ordinary clay oblique silt in the silt oblique clay mining permit area covered by this page 15. Sorry, 102. Please, 1, 2, 3, 4. Till the next date of listing. Next, the petitioners shall produce a certified copy of the order before the Directorate of Geology and Mining Assam within packet respondent number 1.
Number 2.
No, number 2.
And also respondent number 8, my lord, because these are basically my lord, kind of goons party, my lord.
No, for that, if they do, you file, lodge an FIR, but I'm not directing any directions to the police. If you're agreed, we have prohibited the director.
Lodge.
If you're agreed, then you have to do this.
Hard of June.
All right.
Oh, just a moment. We'll add here, since it's a development work. You see that the liberty is granted to the respondents to apply for modification of the order if so advised.
So I have also raised the power and jurisdiction to my lord.
That's okay, but it's ultimately it's a development work. If they want, they can apply for modification of the order.
But that road does not exist.
So that.
The
It's okay.
construction, what they are saying.
No, I'm not that. Since a development work, I'm giving that
Otherwise,
liberty.
that is there. That is there.
All right.
All right.
Yes, item 10.
May I please, Your Lord?
Just a moment.
In this case, Your Lordship, I may
Just-
allow to
just a
file.
minute. Let's. Yes.
Reliance.
Lordship, in this case, I may allow to file an additional affidavit regarding the status of.
Okay. On the claim made by Mr. S.I. Akan,
Lordship.
counsel for the petitioner is permitted to file additional affidavit. So, additional affidavit in the matter. It's a. The matter is urged Leonard standing counsel for the revenue department and Mr. H. Sharma, runner. Additional senior government deputy are present. List of.
2, 3, 4, and 5.
After filing this additional.
Okay.
In the meantime,
Motion
Lordship can
column
notice-
after such affidavit is filed.
Lordship, in the meantime, notice can issue in the meantime.
No, again, you say we'll
Hello.
have that same order.
Lordship.
It will have no effect.
Lordship. Deeply.
No, because the orders which you are passing,
Lordship.
do only that.
Lordship.
So it will not help you.
That part will come thereafter, Lordship. That issuance of notice.
Deeply.
You, there's also, I think, a division bench order of this court in these matters.
Lordship.
So, certainly,
Your Lordship is the day before yesterday, your Lordship is that Reliance General Insurance Company,
No,
Shashi
but
Sharma, but that, yes,
something is
I have to-
striking me, that there is a division bench order of the court.
yes, yes.
So I'll have to take into consideration that also. If you get that.
Lordship,
please raise it before me. Shashi-
Item 11.
Shashi Sharma is there,
Yes, Lord.
but the fact is.
But our division bench does not,
So
yes.
I'll have to deal with it ultimately.
This is near the land acquired by the National Highway Authority. In this, this year's issued notice. This is not one
You
issue,
should notice.
Mother,
You should
Lord,
notice.
Lord. She has not.
Pendency shall not be a bar for to release the payment if found
Lord.
due. Okay, heard Mr. A. Rashid and counsel for the petitioners. Mr. In the, by filing this petition under Article 226 of the Constitution of India, the grievance expressed by the petitioner is that their land was acquired for the purpose of extension of national highway, and although the houses of the petitioner and the standing trees, crops, etc. were destroyed, the Zirat value has not yet been paid. To the petitioner number 1. I didn't get it. Your synopsis and your prayer are different.
Sorry, Milord. Only Milord.
So what is right? Your synopsis is right or your prayer is right?
Prayer. Only Milord, prisoner one nothing received in it, and 2 and 3 Milord, their prisoner one son, but they received not equal.
No, but it's contradictory. You, in your synopsis, you are projecting that the Zirat value is paid to petitioner number 2 and 3 and not paid to 1. Therefore, it's a dispute. You have to settle it in either in court or in the arm wrestling competition. Unless you know MMA.
One nothing received nothing. That is
Huh?
notice was issued to her husband, and husband is no more.
No, but if it is paid to your son, how can a repetition be maintainable?
No, son they received not in equal
I don't know,
share.
please check up because your
Lordship,
synopsis prayer are different.
then
We have to rely on the pleadings only, not the synopsis, Lord.
No. Synopsis is a part of repetition.
It's
Supreme Court
the
in one
gist
of
of
the
the
cases. Supreme
gist
Court
of
in-
the case, but Lordship.
No. In Supreme Court, in one of the cases, has also issued a notice of contempt. I have that judgment.
But then it come my Friday meal, I'll see again. Another meal I'll be in.
Incorrect discussion in synopsis and the
Right.
list of dates amounts to misleading of the court, and therefore contempt is contemptuous.
Make on Friday meal, I'll today.
No, Friday,
I'll check me and if it's any, I'll.
as the synopsis and prayer are does not match. The counsel for the petitioner seeks leave to make necessary corrections. So the said prayer is granted. The corrections shall be made in the presence of DOJ, the civil pending section, and thereafter the matter will be listed in motion.
Item 12.
May I please?
Just a
Lord,
moment. Just a moment.
The, Lord,
Just a moment. Yes. Mr. Talukdar,
My lord,
he's filed an appeal, nothing has been done.
my lord, in fact, no, my lord, my submission is, there are 2 points, my lord. Firstly, my lord, there is a connected writ petition pending, number 1. Number 2, my lord, appeal is apparently, my lord, filed under section 111. Now, 111 lies against an order passed by a subordinate officer. Here, what is alleged, my lord, is inaction. So, my lord, this triple one is not available against any inaction. But if the ARCS is duty bound, statutorily, my lord, if it is required, then your lordship can pass a issue
No,
amendment.
no, here it is projected that the respondent number 7 has been allowed to hold office of the president, and therefore he has filed an appeal. So this appeal is, it appears as against some order.
My lord, in fact, these resolutions are taken by the board, not, my lord, passed by any departmental officers. Number
Acha.
one.
Not required, not required. Lordship
therefore-
kindly see page 18. Page 18 is the resolution by which the respondent number 7 has been, my lord, removed by of no confidence motion. That, my lord, ought to have been approved by the RCS. But RCS is, my lord, holding the, my lord, resolution. Now, where should I go, my lord? Since no action has been done by the RCS, we have no option except, my lord, file an appeal before the registrar. Page 18 is the, my lord, resolution.
18. And what is the other?
Connected
petition pending?
petition, my lord, is 819/24. It is filed by respondent 9. So I don't know, my lord, what is there. Perhaps, my lord, this petition may have some bearing. my lord.
Okay. Mr. Ranjan. WPC
819/24.
of 2024. Just see the last order. If any stay is granted, we'll get print out.
মই কালি দেখা পালো, মই অৰ্ডাৰটো চোৱাই নাই।
Thank you. This is Kukur Mara Samavai Samiti Limited,
My lord,
right?
correct. So, my lord,
Then
I think, my lord,
there's an interim order.
yes.
Impugn order of 21/12/23 remains stayed.
Right.
What is 21/3?
This is not part of the record. My lord, I submit, my lord. Lordship may take up both the matters for avoiding any conflicting orders.
Yes.
No, it's okay.
My lord,
You only issue a notice right now.
my lord, correct.
You take it up. The
জানা নাই আছে তো মোটা এইটোত আপুনি হেৰি কৰিব লাগিব চবে বস্তু নাজানো নতুন বাকী কৰিব
Oh, no. You see this? I think the earlier repetition has become infructuous. That's it. No, you'll have to read the entire order, then you'll understand. Raji.
Oh, sorry. Right. There was a problem. Orders.
So this is subsequent, what do you call, board meeting? And no confidence,
I think it is,
motion is adopted.
it is relatable to my lord, same thing. This is relating to no confidence meeting.
No, but that was of, previous year, September.
My lord,
This is of September, last year.
yes, yes.
Now this is a board meeting of,
28/3/2024.
28/3/24 is subsequent.
My lord.
Because this repetition, the order is of February.
Well.
So this is a subsequent event.
Well.
I'm issue a notice.
Well.
Why is it not given? Okay. Just pass that. Yes, please, sir.
Or may I pray, let it be listed on Friday, along with their WBC, since
That can be done.
Okay. All sides are represented. No, not all sides. The petitioners and the respondent numbers 1 to 6, 1 to 5 are represented.
No.
The,
One of my land extent cannot justify my prayer is.
no, I'm not saying 1 to 6. I'm not saying government or,
No, no,
I'm not saying they are represented.
No.
Mr. S.K. Talukdar, Leonard, standing for the Registrar of Cooperative Societies, has brought to the notice of the court that in connection with the same society, another petition being WPC 819 of 2024 is pending for disposal before this court. Next, accordingly, to avoid conflicting orders, list this matter again in the motion column on Fridays, 5/2024. That the records of WPC 819/2024 be tagged along with.
Responded one chief secretary, my lord, is unnecessarily, my lord. Chief secretary has no.
see that the state is represented by the chief secretary, not by any other secretary.
Principal secretary is already there, co-person department.
Yes, okay. Next time, please remind
Yes,
me, we'll
yes,
strike it
correct.
out. Just remind me on the next date.
My lord.
Item 13.
Mr. Cal is in other court, his engineer informed me, my lord. Can you take up some time, my lord?
Hmm?
Mr. Cal's junior informed me, my lord, he's on legs in other court. After some time.
Item 14.
May I please finish? In this matter, my lord, the land of the petitioners, my lord, 180 bigha, more than 180 bigha was transferred to the selling surplus land, my lord, without the opportunity hearing to the petitioner, my lord, in the keeping dark to the petitioner, my lord. Because the petitioner is doing the tea cultivation of the land, my lord. But by the impugn order, the respondent held that the land was used for other purpose, my lord. Whereas the land absolutely used for the tea cultivation, my lord. According to the land record was also corrected, my lord. The mutation has been done, my lord. Earlier, one committee was constituted for hearing, my lord. That committee report was not provided to the petitioner, my lord. Directly, the committee reports sent to the deputy commissioner, and the deputy commissioner was the impugned order without.
Where is the order, impugned order?
Impugned order Annex J, my lord,
Page,
case 178, my lord.
178.
My lord.
Okay, we'll issue notice.
But Lordship, may I place Lordship one thing? Most probably this, it's premature Lordship, as because they have preferred a representation that is on
Right.
16:4. Let me complete. That is on 16:4 at
No, but
page last.
you corrections were made.
Yes, Lordship, the
The-
details here they have narrated at
Because-
page 215.
No, because this is, I had forgotten, therefore I have read it now. Against orders passed under section 4 of the of this act, Assam Fixation of Ceiling on Land
Selling
Holding
that,
Act,
yes.
there is no provision for appeal.
Yes.
The appeal under section 11 and 12 is permissible only in case of, in the issue of compensation. So there lies the difficulty. If the land records are corrected,
Then Lordship, let the notice go at this.
that is one part.
Yes,
There is an ancillary part. The ancillary part is that this is a tea land. And in the act, what is ancillary operations of a tea garden is also defined. So therefore, in this case, the projection is that the part of the land is used for auditorium and all.
Yes.
That is a change of user, and therefore Land Ceiling Act technically can be applied.
That is
It
well,
is-
Lordship. I have gone through the impugned order, which is impugned here, Lordship. Yes, Lordship. But that pendency shall not be able in disposing of that. That can also be done, Lordship. Maybe he will get that relief. Most probably because of this election, the 16th of April, they have submitted this representation.
You will maintain the status quo of the land. There will be no third party rights can be created. Heard Mr. S. Saikia and counsel for the petitioner. But Mr. Saikia, you have to satisfy us on one more thing.
My lord.
You are a society.
Yes, my lord.
Now, is your society permitted to do business in the
No, my lord. This is
tea?
especially non-profit organization, my lord. I especially mentioned in my,
No, no, no.
my lord,
Tea as an industry,
my lord, my
no
lord.
question of no non-profit. It may be a loss-making concern,
Yes, my lord.
but are you permitted to do business?
Yes, my lord.
Where is that?
Lordship may kindly come to page 215, last two lines.
215.
215. This is the representation submitted by the society, last two lines. Please note, has your Lordship got?
Just now.
Annexure Q 215.
Yes.
Please note also that the owner of the land is not Don Bosco University, but Don Bosco Society Azara. The university is sponsored by Don Bosco Society. So, Lordship, it's
No, that is one part. But they are saying that it's a tea land and they are doing tea cultivation. Too many things in the mind makes it confusing. You see, what happens is that for a tea plantation, for somebody to do, you have to have a registration under the tea board.
Lordship.
So it's not an what do you call the license, though transferable.
Yes.
But a fresh license is issued in the name of the owner of a tea estate. So it's not a tea estate, but the owner who gets a registration under the Tea Act.
Yes.
That's one part. The second part is that the society, the name suggests, is an educational society. They may sponsor a university, no doubt with that. but to do business.
Lordship.
There's something they'll have to satisfy that they are empowered to do business.
And the,
Where is that?
and the order impugned, Lordship, it is specifically mentioned that they have cut that tree bushes and established that university as well as cafeteria, etc.
It's a non-profit, I especially mentioned in
No,
my petition.
non-profit is okay.
Non-profit organization, my lord.
Non-profit is okay,
My lord.
but you see, let us take a name,
My
for
lord.
example. My examples are always horrible. This is
Yes,
one of the other horrible examples.
Yes, ma'am.
You see, the Tata Trust,
Yes, ma'am.
it maintains a cancer hospital in Bombay.
Yes.
Maybe they say that we have so many industries, but the intention is not to earn profit. All profits are diverted to this cancer institute. Correct.
Yes.
So what happens? What happens to that entity? It's not a non-profit entity. It makes profit and it diverts it for philanthropic causes.
Ma'am.
So no profit is, we are not concerned with that. The concern is whether you are empowered as a society to do business.
Yes. For that reason, I have to take instruction. my lord.
Do it.
Yes, ma'am.
You take it up day after tomorrow.
Ma'am.
The society must be permitting that.
No.
Non-profit is okay.
Yes.
Mr. Ibarasari, Responsible for the Revenue Department, and Mr. H. Sharma, and additional
Two and
that
three.
were present. To stop. The pair made by the council to the petitioner, list on Friday. Third May.
Lordship.
Suddenly a funny thought came into the mind. I'll just share it. No meaning should be attributed to it, just a loose talk.
Yes.
When I was there in your side, we had many friends, lawyers, who did not charge any fees. They would take only cost of 20,000-30,000 rupees. No fees was charged. I had friends then. Okay,
Lordship.
I'll take a break and come back.
Item 15.
May I please, your lordship?
Yes, Mr. Mia.
My lord, my prayer is very limited, my lord. My lord, we have taken recourse to the civil remedies for a disputed land, my lord, and wherein, my lord, we are the absolute possessors of the said land of 3 bighas. But my lord, the some antisocial elements and goons with the aid of some political persons, my lord, is now trying to convert the land into Idgah. And therefore, my lord, they are using some pressure and we are approaching before the police.
Come to page 54, 55.
My lord. Yes, my lord,
You already have an order of civil court of status quo.
status quo order is there, my lord.
can't
Status
do anything
quo,
more.
but my lord, that the, after this, my lord, we have even filed a contempt petition. That contempt petition notice has also been issued. But even thereafter, my lord, they are using the criminal
but-
force.
Two parallel remedies you can't permit.
My lord,
We can't permit, because if the High Court is taking up, we will not allow parallel proceeding before the civil court.
my
And
lord.
if civil court is already in session of the matter, we don't find, because of my last so many years of association there, I don't find that the court is not having enough power to
Lordship.
enforce its orders.
My lord, that is an aspect, my lord. My lordship, what our limited prayer, my lord, is that the inaction on the part of the police, my lord. Basically, the
Lordship,
prayer,
they can,
basically,
No, then there are
they can
two
file an
avenues.
application there.
There are two avenues. If you are dissatisfied with the police, there is a police accountability commission.
my lord,
But the problem is that once there is a civil court who is in session in the matter,
my lord.
we can't entertain a writ petition.
Lordship,
That will
the
be-
clash of interest may be there.
No, it's not cash value, but there will be, you see.
As because that,
You see, I'm not, what do you call? I'm trying to be very calculated when I'm speaking this. You see, what happens is that once you file a, we have experienced that
Lordship,
when there is a writ petition pending, these civil courts will just not pass any order.
Lordship.
They are, because of the fact that they are also aware that the Superior Court has taken up cognizance of the matter. Therefore, in order to avoid multiplicity of orders and conflicting orders, normally a civil court will not pass orders. Because that is the difficulty.
they have got the power, Lordship, to direct the police authority to take action because their order is there, Lord. That status quo order is already there.
Or my lord, may I pray, my lord, if at least an instruction is sought for, my lord, regarding from the police, my lord, that what they have done regarding our affairs and complaints. On next date, my lord, we can even withdraw the petition
Yes,
on basing on the instruction also, my lord.
The same thing will happen,
No,
Lordship.
that's difficult.
My lord. Because the police is also not at all helping us, my lord.
Where are your representations before the,
My lord, before the superintendent is at page 56, my lord, and
just a moment.
my lord.
The subsidiary
Who is
PO.
respond number 2?
2 times you
Director
have
of Police, he will not do anything. Number 3 is Superintendent of Police.
my lord.
Where is that representation was Superintendent of Police?
Is
Page
that page, my lord, 56 is a
56.
representation, my lord, dated 29/2/24. And another one, my lord, is at page 60, my lord, dated 7/3/24, my lord.
Just a moment.
GP to receive, no? Even, my lord, we approached the Director General of Police also, my lord.
You have a copy of your plaint or the injunction application?
My lord, that copy today I have not available. I can produce before my lord, my lord. Income to the position of it. Maybe. $26 of Muslim. $26. My lord.
No, there is a reason why you don't have that injunction application. You come to page 52. Page 52 is the preliminary order. You just omit this part. Come to page 53.
My lord.
53 says the plaintiffs have also filed a plain petition under order 39(1) and 2,
My lord.
read with so and so, with prayer for granting ad interim injunction,
My lord.
restraining the principal defendants from alienating to suit land.
My lord.
Fixing it 26/4. That is why I'm asking
no.
what happened on 26/4.
No, that's not the point.
My alienating, my lord.
For alienating.
My
So
lord.
therefore, order of status quo is only in respect of alienating. It can't be beyond the prayers made. Therefore, your prayers made in the plaint
My lord.
and in this writ petition is contradictory. That is, itself is a good ground not to entertain.
My lord, I have not even gone for the plaint also, my lord.
No, we know that now.
My lord,
It is a judicial order.
my lord. That alienating I have.
So status quo must be read with the nature of prayer made in the plaint.
My lord.
It can't be anything more. So what you are wanting before the police is against your own petition in the injunction application.
No, injunction, my lord, we have prayed that this land, suit land, my lord, which is there, it should not be, my lord,
Alienated. So you get an order of status quo. What does it mean? It will not be
status quo,
alienated.
It will
It
remain.
can't
as-
mean
My lord,
that no construction will go up, that
Right.
the status quo cannot
Exactly.
be read to mean that no earth filling, no
Exactly.
construction.
Exactly. But even thereafter, my lord, they have doing the earth filling and construction.
Definitely they will go on. We'll also permit them.
My lord,
In your petition, we may permit them to do it, to go ahead. We'll clarify that the status quo order should not be read beyond the prayers.
my lord.
But the fact is
Then,
that
my lord, may I pray that this matter may be taken up on next Monday, my lord. I will take the instruction regarding that part, my lord.
okay.
My lord. I know, my lord.
Mr. A.R. Bhuyan and counsel for the petitioner and Mr. H. Sharma, learned additional senior government advocate appearing for the respondents.
Alienating of process.
Next paragraph. The learned additional senior government advocate has referred to NHS 6 to this writ petition to project that the prayer by the petitioner in application under order order 39 rule 1 and 2 CPC related to restraining the principal defendants from alienating the suit land. Full stop. We find that the grievance in this writ petition is that land development activities are going on with the said land, which is subject matter of title suit number 18 of 2024, pending before the Court of Learned Civil Judge within bracket Senior Division, bracket close Karimganj. Full stop. Therefore, the prayer and projection in this writ petition appears to be contrary to the nature of prayer made in the injunction application. Next, according to the Learned Counsel for the petitioner, this was some time to obtain instructions and to produce a copy of this plaint and
Yes.
injunction application. Next, matter stands adjourned today, list on 6th, you say, 6/5/2024.
Item 17.
Right.
Your Lordship.
Yes.
Lordship, this writ petition is filed by the petitioner for the mutation of the land purchased by him, Lordship. He has applied for the mutation, but till date, the land was not mutated in his name.
Where is your application? Or the acknowledgement, where is that?
Sorry? One application we have annexed, that is annexure 3, page 20.
But after this, you'll have to file an appeal. If you're showing us page 20,
Yes, my lord. To my verbal instruction, my lord, I have tried to make an inquiry, my lord, whether it is pending or rejected. They have stated that it was rejected on 21/9/2023.
21/9/2023.
23, but
Get it.
details,
It's okay.
details I could not get to them.
Okay. But, huh? It's okay, but if it is rejected, question of the, what you call it, will be a totally different approach then. Heard Miss
A Bora,
A. Boral and counsel for the petitioner. The application for mutation submitted on 21/2023 is stated to have not been acted upon. And therefore, this writ petition has been filed under Article 226 of the Constitution of India.
there is also one prayer made to the DC Lordship, that is Annexure 4. Annexure 4, page number 21. The petitioner have also prayed to the DC for the mutation of the land.
Page
Page 21.
21. Okay. Next paragraph. Miss M. Burman, and a government advocate, has submitted that as per verbal instructions received by her, the mutation application has been rejected by order dated
21/9/2023.
21/9/2023. So, however, she submits that this is only by verbal instructions, and she awaits formal communication in the matter. Next paragraph. Ms. P.R. Montalanet, standing counsel for the Revenue Department, submits that if the what is it called? What is the name of this service? Designated service?
Under right to public service.
No, this, what is the term used? What
Notified service.
Notified service. If the notified service is not made available within the, in a time-bound manner, the provisions for appeal is available under the Assam Right to
Public Service
Act.
Act.
Next, be there as it may. We permit the learned government advocate to obtain instructions. List on, list in the motion column on. We make it 10th, you may not get the.
My
getting
lord, that is
information.
why I'm trying to raise after 7, after
Maybe
10.
13th May. Okay,
Oblige.
13th May.
Item 18.
Yes, Mr. Rahman.
Mr. Before Lord, sir, 10 elected board of directors of cooperative society, my lord. My lord, against the, my lord, illegal activities of chairman and secretary, my lord, they have filed a complaint before the ARCS as well as register, my lord. Thereafter, my lord, that was not, no steps was taken, my lord. Accordingly, petitioner filed, we have filed this petition before this honorable court, seeking direction to dispose of the representation filed before the register of cooperative society after hearing all the necessary parties, my lord. My lord, now, my lord, yesterday, my lord, the client has received a notice from the auditor, senior auditor, my lord, cooperative society, whereby, my lord, and inquiry was directed to conduct on, my lord, 8/5, my lord, on 8/5. So accordingly, my lord, matter may be listed after 8/5, my lord.
No, but even otherwise,
My lord.
how will this repression be maintainable? If the chairman is not doing what is required
Chairman,
to do-
secretary in negotiation with some officials, my lord.
It's okay. You file a requisition meeting, you hold a meeting, nothing prevents you from doing it. How will a repression be maintainable? that the chairman is not working, take steps against chairman, and the authorities don't do it, and you come to High Court. How, what the court, what will we do?
There is a provision of section 87, my lord. If any illegality is going on, then they can file an application before the registrar, and thereafter registrar may inquire into the matter, my lord, section 87. And accordingly, within 10 days, my lord, he has he has directed the senior, my lord, audit officer to
If
inquire
you
into the
don't
matter.
want the chairman, you can move a no confidence motion against him.
My
Who
lord,
is stopping you?
there is a problem, my lord. Here are 10 members, my lord. Out of 14, my lord, at least 3/4 is necessary, my lord.
So
12 is
therefore, the
necessary.
situation is just like,
It is the
just
concept, my
like
lord.
the
Concept
home
is
minister,
too tight.
just like the home minister in my home. I may have 101 grievances, but I have to live with it. That's what you want to say. For that, we can't have a writ petition pending.
Then,
You can move the family court if you want.
my lord, right now I want to draw it
Huh.
with liberty, my lord. Otherwise, if I agree by that order passed by on 8/5, then I may. Otherwise, my lord,
But you'll have to excuse me, my examples are always horrible.
otherwise your lordship may also think the matter after 8/5. That is up to your lordship, my lord.
No, you will do it. If you want, you do it. Mr. B. Rahman, the counsel for the petitioner, petitioners seeks to withdraw this application, writ petition, and to avail alternative remedy. To stop.
Well,
Mr. S.K. Talgal and standing counsel for the Corporation Department and Ms. M. Burman and Government Advocate are present. Matters are dismissed from withdrawal with liberty aspect.
Time being item 4.
But you made me expose my own home. Yes, you got information.
Here I have not received the information. Can you keep it after 7th, on 10th or on 10th?
On 10.
On 10th.
Mr. J. Kalita, counsel for the petitioner is present. Mr. D. Nath, learned as senior government advocate, submits that he could not obtain instructions as to whether the Assam Board of Revenue is fully functional.
Appointment has not been done.
No, it's okay.
That much I know.
Only fully
What
functional.
steps they have taken, I'll get that instruction.
And steps, if any, taken by the appropriate government.
Madam.
To stop. Matter is adjourned today, list on 13th May
13th.
in the motion column.
Supplementary item 49.
Matter is to challenge of notification whereby the time limit was passed certain orders, my lord. I'm paying for similar orders. Where is that? Beyond time limit. I'll just supply the orders, my lord. Make the corrections. My lord. Just show it to Mr. KL. My lord. Yes, I'm satisfied. Okay, just make that correct. My lord. Same order. Item 9 is also same. Item 13 also same. 13, 13. 13 and 49. This 13 and 49. Okay. Deeply obliged. When should we fix, Mr. KR? When should we fix the matter?
10th, Lordship, normally 10th has been fixed.
Okay.
I've received instruction, but we could not file our affidavit. Lordship.
Okay.
Probably will by
Let's
that
fix
time.
10-5. Okay.
Obliged.
Yes.
Make the year also. This matter relates to an NIT for procurement of certified seats by the Assam Seat Corporation. My lord, there are two offending clauses. Before I take your lordship to the clauses, may I take your lordship to the NIT?
You should be thankful if you're not allowed to participate. In the last year tenders, everybody is in court. For non-payment of dues. Yes, but this restrictive.
My lord, there is no any such thing which otherwise they would be prejudiced. Number one, my lord, can see 118 for a moment, please.
It appears to be restrictive.
No, my lord, absolutely. Lordship, I make the
Then
position
we'll
clear.
hear Mr. Chaudhary first.
Yes, my lord.
No, we'll hear you first because he says that there's nothing here.
Nothing prejudiced.
Therefore, we'll hear you first because I had a preliminary idea that you have a
Whether
case. He
they'll
says
contest
that,
or not, my lord.
he says that you don't have a case. So therefore, I'll hear you first.
Then I'll let me satisfy your worship, my lord, that I have a case.
Yes, yes.
My lord, the NIT starts at page 26.
26.
26.
Yes.
Your worship will kindly take note. For procurement of fresh certified seeds of different crop varieties for the year 2024-25.
Yes.
Now, my lord, this certified seeds are those which are, my lord, the producer, they certify it. And my lord, I am a, my lord, contractor. I'm a registered contractor under the government, and I have to buy from them and, my lord, deliver it to the my lord, the NIT by the my lord corporation. Now, if your lordship kindly turns to page 31.
Just one minute.
Because of there are various types of seeds, I'll come to that a little later on. But certified seeds are those which are certified by the my lord, the producer. And I don't have any role there. I have to get it from them and deliver it to the corporation.
Yes.
Page 31, your lordship will kindly find.
Certified seed is a seed of a known variety produced under strict seed certification standards.
Yes.
To maintain varietal purity.
Yes.
Okay.
Now, page 31, your lordship will see the clause 2. Open competitive bidding method shall be followed for selection of most preferred bidder for the tender items. The tender items, tender terms, conditions, and procedure are in conformity with the Assam Public Procurement Act 2017, the Assam Public Procurement Rules 2020 as amended from time to time. I'll satisfy your lordship that, my lord, they are not following, not in terms of, my lord, the procurement rules. The last date, clause 5, was 28/3/2024. But then, my lord, there have been 3 corrigenda and there have been extension of time and change in the conditions. Now, I'll take your lordship directly to the, my lord, offending clauses. Those are at page 63.
Just a moment. This clauses appear to be very familiar. Similar challenge was made last time also, Mr. Chaudhary.
Lordship, it was in context of another.
That was in context of those, what you call, what is it called?
Trade suppliers, my lord, the body was trade suppliers.
Micronutrients and all.
Micronutrients, bio, pesticides, all those things.
No, and one, what you call, word starts from S. To preserve that forest.
Lordship.
Saplings or.
Oh no, it was regarding, my lord, the case that I did was.
Last year there were many repetitions.
Lordship, that conditions are similar that RE traders, Lordship, it was with regard to another tender, Lordship. But the items I can't remember at this moment.
Oh, okay. The one plant was from S. They were to be procured and distributed within 2 months. Sorry, within 20 days or 10 days to all the districts. The conditions are similar. That's why I'm asking. What happened to those maintainability of those repetitions?
Lordship, those were disposed of, Lordship. In favor of the department, Lordship, as far as I remember now.
Okay, listen.
Well, the offending clauses, your lordship will get at page 63.
63.
63. These are the, my lord, qualification criteria. As your lordship got in, my lord, page 63.
Yes.
Required minimum experience. The bidder must have experience of supplying certified seeds to the government departments, undertakings, entities, PSUs to the extent of at least 20% of the estimated quantity for the schedule of item that is against each particular crop in the certified seed business during 2019-20 till my lord 2023-24 till the last date of submission of bid. Then clause 2, the bidder must have experience of supplying TL seeds to the government department undertaking entities PSUs to the extent of at least 20% of the estimated quantity for scheduled item in the TL seed business during the 2019-20 to 2023-24. So my lord, this is regarding my lord the experience. Then next page your lordship will find clause 4.2.2.
Yes.
Financial standing. The bidder should have at least an average annual turnover of rupees as mentioned in the table below, 20% of the quantity for schedule of item that is against each crop during last 3 financial years, 2021, 2021, 21-22 and 2023, ending March 2023. Now, my lord, I am challenging these two clauses, my lord, primarily on 3 grounds. Firstly, my lord, this is arbitrary. Secondly, that this is not my lord, these clauses are not required for the purpose of the my lord, the object sought to be achieved by the my lord tender. And thirdly, at about the same point of time, there are other 2 tenders I have annexed that, and these conditions are not there. Now, if I take your lordship, my lord, there are 2 corrigendum. Last corrigendum, your lordship will find at my lord page 108. There, your lordship will find.
Now, let us see, for example, you are showing us page 64.
Yes.
Let us say annual turnover of black gram is 6 crore 42 lakh.
Yes.
Now, what would be the estimated price of the supplies you are going to make?
My lord, the question is, my lord, whether this experience is required and for what purpose, my lord? Because I am a contractor, registered contractor under the department, under the government. And my lord, I have got the license to do this business by procuring it from the producer and supplying it to the, my lord, the intending department. Therefore, the question of why, my lord, that experience of is required, my lord, that is my lord, beyond the purpose of
I'll tell you, last time, as I said, many things in the mind makes me confused. You see, last time the argument was that the supplies were to be made within a fixed period of time. It was a aided project, internationally aided project, and therefore the supplies were to be made within a time limit. And it was demonstrated that it would need some amount of cash liquidity with the vendor. Now, what you call right now there's a lot of issue going on in the trade circles because of MSME Act. You must be aware of the disputes which are now coming up, and it has led to collapse in business of some fronts.
Some MSVs.
Some fronts, not MSME, it's some fronts.
Yes.
What is happening is that the requirement of making a payment within 45 days is hitting the business, and therefore they have stopped purchasing it from MSMEs. Now, incidentally, this Public Procurement Act, even the government of Assam is not following because of the requirement under MSME Act where you have to make payment under 45 days. And therefore, they have, in their agreement, they have clauses to exclude MSME Act.
Yes.
Preferential purchase is almost being done away in this. This is second aspect.
Right.
The third one is that if otherwise you have to procure that value and then send it, if you don't have a turnover, that means you'll be dependent on borrowed finance.
I get your lordship's query, my lord.
So that is why we are wanting to know, because that was an argument which was vehemently made on the last occasion,
my lord,
justifying why there should be a higher turnover and the those.
My lord, I get your lordship's point, my lord.
For that, my lord, I'd like to take your lordship to the other tenders which have been
Yes,
issued. my
yes,
lord.
definitely.
Because, my lord, that can be taken care of by bank guarantee. If your lordship kindly comes to the, my lord, the other tenders, there are two other tenders, my lord. One is at 120. Page 120. Same authorities have issued the same, my lord, type of tender. Page 120, this is, my lord, for procurement of hybrid seeds of different crop varieties. So only, my lord, that was earlier was certified seeds, and these are hybrid seeds.
Yes.
Then your lordship may kindly come to page 156. Regarding that, my lord, clause 4.2, there in the earlier NIT that I have challenged, that your lordship would finds at page 156. Qualification criteria.
Page number
156.
156. Financial soundness certificate from bank.
Financial soundness certified from bank. And so far as experience 4.2.1 is concerned, required minimum experience. Minimum experience anyone, my lord, who has done for the last 2-3 years may have. My lord. So there, my lord, this is not rigid. This is the requirement. In the other tender, this tender is dated, my lord, 8th of March. The next tender is 11th of March that your lordship finds at page 207.
First is 8th of March. First tender is 8th of March.
8th of March.
Second is?
Second is, my lord, 11th of March.
Yes.
In fact, my lord, the tender which I am selling, my lord, that is also 8th of March. On the same date, my lord, 2 tenders have been issued. After 3 days, my lord, another tender has been issued. That your lordship finds at, my lord, page 207. For procurement of hybrid vegetable seeds of different crops or varieties for the year 2024-25. The eligibility clause your lordship will get at 242.
That particular page is?
207 is a, my lord, another tender
Yes.
dated 11th of March regarding hybrid vegetable seeds. Eligibility criteria given in this tender is available at page 242. Ditto as the earlier one.
Okay.
In fact, my lord, in these 2 tenders, there is no certification required. And that's why perhaps, my lord, it was more necessary that if you put that condition at all of an experience, then, my lord, these 2 tenders would have been, my lord, more suitable for that. Now, your lordship will kindly come to the, my lord, Assam Public Procurement Rules 2020, which I have annexed at page 248. Sorry, my lord, 284. Because, my lord, they have professed in the NIT itself that they are following these Public Distribution Act and rules.
Yes.
At page 287, your lordship will find under the head Code of Integrity for Procurement Entity of Bidders, page
287.
287. I'll be referring to clause Roman 3. Page 287. The last one in the last entry in the on this page. Not to use or include unnecessary restrictive or tailored specifications, terms of reference, statement of work, limitation or terms and conditions that may discourage wide competition or unnecessarily exclude certain categories of prospective bidders from the participation. Now, my lord, here I pause for a while. In the, my lord, the two other tenders which are not under challenge, my lord, I am eligible to participate. I get some work. Then, my lord, that gives me some experience. I participate on next day, next year also. I gain more experience. After a few years, when I become a blue-eyed boy of the department, my lord, then this condition is imposed that you have to have experience for 5 years. My lord, in fact, because of lack of time, I could not, my lord, annex the earlier NITs where this clause was not there. So they selected someone, some parties, which are blue-eyed boy, and my lord, let them gain the experience. Then after some time, you point out, oh, look, so this has to be, we have to protect them. Therefore, we impose this condition. And that is how, my lord, the competition is sought to be, my lord, narrowed down. Your lordship will look into this matter, my lord, whether it is a certified, my lord, seed or hybrid seed or any other seed. My lord, the contractors are not producing it. The certificate is issued by the, my lord, producer. And in the subsequent two tenders, there is no certification required. Anybody can come and participate. Then what is the, my lord, need of that particular clause, except that, my lord, you want to exclude and tailor make it for certain, my lord, certain groups. And by that you violate this provision also.
But what happens to that, all those suggestions from Jagdish Mandal to NG projects where it says that the clauses, they are the masters to form the tender conditions, and that has to be respected. That's what.
No, that's there, my lord. But then your worship knows, my lord, at least there are many cases of the Supreme Court where, my lord, the law has been laid down. It is there, my lord. They can give the, my lord, terms and conditions. But then, my lord, there has to be, my lord, some reasonableness. And, my lord, I refer to one decision, Michigan Rubber, your worship knows, my lord, one paragraph I'll read from that. Michigan Rubber is, my lord, 2012 8 SCC 216. 2012, volume 8, SCC 216.
Just now, 2012.
Volume 8. Page 216. The principles laid down are.
Just a moment.
I'm sorry. There are other decisions. I'll only refer to this, my lord. It has summarized the law. Because your lordship has to look into the fact whether these particular conditions are essential or not to achieve the purpose for which the NIT has been issued. Your lordship.
2012 8 SCC 216.
Yes, my lord. I'm sorry, my lord, I did not give.
No, it's not coming up.
Because your lordship always.
No, it's not coming up. That's why I'm saying. Michigan Rubber.
May I supply my book?
No, it's okay. We'll get it. Yes.
Paragraph 23. May I read it?
Yes.
para 23, from the above decision, the following principles emerge. The basic requirement of Article 14 is fairness in action by the state, and non-arbitrariness in essence and substance is the heartbeat of fair play. These actions are amenable to judicial review only to the extent that the state must act validly for a discernible reason, not whimsically for any ulterior purpose. If the state acts within the bounds of reasonableness, it would be legitimate to take into consideration the national priorities. The fixation of a value of the tender is entirely within the purview of the executive, and the courts hardly have any role to play in this process except for striking down such action of executive as is proved to be arbitrary or unreasonable. If the government acts in conformity with certain healthy standards and norms, such as awarding of contracts by inviting tenders, in those circumstances, the interference by the court is very limited. C. In the matter of formulating conditions of a tender document and awarding a contract, greater latitude is required to be conceded to the state authorities unless the action of the tendering authority is found to be malicious and the misuse of its statutory power, interference by courts is not warranted. D. Certain preconditions and qualifications for tenders have to be laid down to ensure that the contractor has the capacity and the resources to successfully execute the work. And E. If the state or its instrumentalities are reasonably, fairly, and in public interest is awarding contract, here again, interference by court is very restrictive since no person can claim a fundamental right to carry on business with the government. Therefore, my submission is that in the light of these principles, your lordship will consider whether, my lord, these two restrictions are necessary, which will prevent competition and which will apparently is a tailor-made, my lord, the conditions.
Continue to.
Discussing the earlier decision of the Honorable Supreme Court. Therefore, I will not burden your lordship with any other decision. My submission before your lordship that the Sikh corporation has to show now and satisfy your lordship that what is the difference between these three tenders. Because, my lord, I have experience. I have got financial standing. I am supplying to them, but it does not meet that standard which has been now restrictively imposed on us. And your lordship knows that, my lord, that famous sentence of Albert Einstein, that a fish cannot be judged by its ability to climb trees. What we are doing here, we are getting it certified from the, my lord, producer. And there are three classes of participants who can participate. One is the producer, one is the dealer, which I am, and third is the exporter. And, my lord, dealer's license, I have annexed, my lord, that is very strict. They have also, my lord, identified the, my lord, items which I can supply and which I am supplying to them, some of them. Therefore, my lord, this requirement has been, in my submission, is, my lord, put only to, my lord, keep it limited to a certain number of bidders, to the exclusion of others. What I want, my lord, I want to participate. I do not say that I must get the contract. But why are you preventing me from participating? And they have to show, my lord, satisfy your lordship that, my lord, there is difference between these three tenders. They have issued almost on the same date.
Lordship, the pertinent question, let me allow to address first that what is the differentiation between the two tender and the tender which they have put on the question. Now, Lordship, so far the hybrid, the first two tenders are concerned. These natures and features are totally different from the certified bid process, madam. I'm making the differences. What are the differences? Now, Lordship, so far the hybrid are concerned. that has been led by the reputed company, and the authorized dealer only will participate. Therefore, the company which use their tech, that would be used for the purpose of hybrid. Any responsibility, any liability, that will directly go to the company. Number one. Number two, my lord, kindly see that a time is a factor. Here, my lord, in both my lord session, Rabi and my lord, this Kharif, entire session, we have procured this hybrid process, my lord, where the company is under monitor, their credentials that has already been tested and everything that has been verified. Then, my lord, there will be, if any casualty happens, my lord, then they would be, because their soundness, everything, my lord, already been calculated. Therefore, time is a factor. Now, third point is that, my lord, here is a case, my lord. Suppose, my lord, the turnover issue is concerned, my lord. We know that what companies perform what in last past, my lord. Therefore, that's why we have called it is not a case, my lord, that in hybrid we have totally off the conditions. It is not that kind of case. So this difference in this is the classification in respect of hybrid. Now I'm coming to the second part, certified bid, which they are putting on the questions. Now, so far the certified bid is features and nature are totally different, my lord. Here, my lord, this entire process of procurement of certified seeds was from a, my lord, process which has been guided by the particular guidelines of, my lord, agriculture department, which has been, my lord, formulated by the expert of, my lord, in this field, my lord. My lord, here is a case, my lord, the certified bids, my lord, that has to be, my lord, procured by the farmers from the bidders, my lord, which has been certified by the particular, my lord, producing unit, my lord. And, my lord, this particular seed which now they are intending to supply, that would go through the process by the certificate agency, my lord. My lord, the first part is that the grower.
The first part I am not getting it. I am stuck in first part.
Sorry.
Because you see, to my limited acquired knowledge, the difference between a certified seed and a hybrid seeds is that a certified seeds have a progeny of 3 generations. That means first plant, from there seeds or something, second plant, third plant. Third plant gets the progeny of being certified as a certified seeds. And hybrid, it can be less. So there's no difference between the hybrid seed and a certified seed, except for its 3 generations. Because if I have a known lineage, starting from my grandfather, my father and me, 3 generations, so it becomes a certified seed. That's all. So the second part of your submission, that the responsibilities are taken up by the supplier, is something which is foreign in agriculture. I have not come across any theory, at least in botany, where somebody can take a guarantee about the seeds.
Yes, my lord. That's why, my lord, because certificate agency plays vital role.
It's not there in the botany. Because these are germinating seeds.
My lord.
Seeds, you see, I'm a man of commerce, so less said is better.
My lord.
But the fact is that the seeds, there is no guarantee that it will sprout.
My lord, absolutely, quite right. Sometimes happens, my lord.
So therefore, you can't. This is a component in the plant life where you can't sue that I have planted roses and it doesn't. The flower doesn't give, the rose plant doesn't give me a flower.
My lord, my lord. Now, lordship, quite right on this point that the hybrid and certified particular definition is meaning thereby, my lord. But lordship, kindly see that so far these 2 parties concerned, my lord, which, my lord, we have removed that condition which is otherwise not in, my lord, there, which are here, my lord. Certified seed, my lord, totally in tie-up with the farmers, my lord, which is not the part of dealing in case of hybrid, my lord. This is, my lord, in respect of certified bid. Second part, my lord, that so far the certified seeds are concerned, my lord, which is, my lord, truthfully labeled, it has to be, my lord, routed through the certificate agency, my lord. The certificate agency from stage to stage, my lord, certify the seed, then, my lord, it would be supplied to the concerned farmer, my lord. So therefore, my lord, it will secure the interest of the farmers at large, my lord. Now, third thing is very important, my lord. My lord, hey, now the so far this present seed is concerned, my lord, certified seed. We have to supply this thing in this Kharif season, which we start from May to 10, and it will be completed in the month of May, my lord. Only 20 days remains in our hand. Suppose, lordship, we remove these two conditions. First, experience, my lord. Then anybody will come, my lord, and he will join, my lord. And suppose in middle, my lord, he failed to suppose supply or quality seeds, my lord. Ultimately, farmers will be affected. Second, my lord, liquidity person, financial liquidity person, my lord. My lord, he start the my lord, procurement and supply. In middle, my lord, he suppose stop. The entire project will be go, my lord. Lordship, kindly see that the condition which we have imposed, that is only 20%, my lord. My lord, any good persons who has financial, my lord, soundness or experience criteria, my lord, if he doesn't have 20%, my lord, my lord, capability, my lord, how we can trust that he is eligible to supply this, my lord, huge quantity of seeds to the farmers, my lord? Therefore, lordship, last.
Why you come at a price tag just like a Bata shoe of 999 rupees 95 paisa?
My lord.
You have given a particular figure. You don't say a round figure that you have to qualify for 5 crore, 10 crore, 2 crores. You've given a very chosen figure.
My lord, reason behind is that, my lord, the figure which we have mentioned, lordship, one important aspect. Last year, my lord, the same process we have adopted.
Yes, exactly.
The same, my lord, two hybrid process we have initiated, and another is, my lord, certified bid process we have initiated. It was successfully completed, my lord. There was no any complaint we have received. But lordship, there is an instance.
Your financial standing
My lord.
is 6 crore 42 lakh 20,000.
My lord.
So that's why I remembered Bata is famous for 799.9995 paisa.
My lord, my lord.
I just remembered at
My
times I
lord.
digress. I don't know why.
My lord. My lord, so far the conditions, my lord, purchase the best persons to judge until unless it is arbitrary, my lord. Now, arbitrary lordship, kindly see, they have only raised one question that to accommodate certain, my lord, suppliers, we have, my lord, put this condition. This is not a fact, my lord. On last year, my lord, we have put the same situations, my lord, where, my lord, so many bidders have participated, my lord. And based on that, my lord, that scheme was successfully implemented, my lord. Now, suppose if that expense now lying in our hand, my lord, if same process right now we will follow, my lord, that will not prejudice to the interest of the farmers. But if we remove this lock, my lord, then lordship, kindly see that what damage it may come, my lord. Therefore, lordship, this condition, whatever we have put, just not for other purposes, but to protect the interest, greater interest of the farmers, my lord, at all, my lord. Now, lordship, kindly see their interest, my lord, that timing, my lord. The bid was floated on 8/3/2024.
Yeah, just a moment. Okay.
Now, my lord, kindly see their approach, my lord. These conditions, my lord, along with my lord, bid was floated on 8/3/2024. 8/3/2024. Now, tomorrow is the last date for submission of bid. Where they were, my lord? If they are so keen to suppose participate this process, or they are so, my lord, interested to someone remove this condition, my lord, they could have come earlier, my lord. At the heart of this, my lord, bid process, if somebody comes and, my lord, frustrate the entire process, my lord, ultimately what happened? Only we remains 20 days in hand. Farmers will be affected at large, my lord. We will not in a position to supply the seeds to the farmers, those who are otherwise, my lord, necessity under the scheme. If suppose one scheme would be failed, next year definitely the government of India will not allot any scheme to us, my lord. Again, my lord, farmers will be affected. Therefore, lordship, kindly see from the perspective of greater interest of farmers, these two conditions, whatever we have incorporated, has certain justifications from the point of view of, my lord, securing the interest of farmers, number one. Number two, my lord, we want that qualified bidders should be there, my lord. Third thing is that, my lord, it has certain, my lord, reasons for behind putting this condition, because it's a time-bound program, my lord. It is not that entire session we will continue this process, my lord, which is otherwise applicable in case of, my lord, procurement of hybrid, my lord, seats, my lord. Therefore, my lord, kindly take into consideration of all facts, my lord. Now tomorrow is the last date for submission. Let them file bid, my lord. There is no any problem.
When is the last date of opening?
My lord,
The date of opening? When is
next
it?
day, my lord. Lordship, page 32.
32.
Sorry, my lord, not page 32. Sorry, my lord. Page
116.
116, my lord. Their whole purpose is to, my lord, upset the entire process of procurement, my lord. At the cost of singular person, that thousands of farmers will be affected, my lord. They will be deprived, my lord. My lord, the last date of bid submission is 2/5. Last date of hard copy of the bid on 3/5. Technical bid opening date is 3/5, my lord. Only 2 days remains, my lord. If this process would not be completed, my lord, that procurement we have to start from the 10th May, my lord. And we have to complete it within 30 May, my lord.
And what is the reason for this two criteria and two different tenders?
My lord, I have given two reasons, my lord. First condition is that, my lord, both are different in nature, my lord. Hybrid stood in different footing, and so far certified bid is concerned, my lord, it stood in a different footing because, my lord, in hybrid procurement that has been done by the company who is the proprietorship firm concerned, my lord, who already produced their seats, and only their authorized dealer from them, my lord, they supply the product, my lord. Therefore, any casualty if happens, my lord.
Where is the tender condition? Please,
My lord.
It shows the tender condition that only
My lord,
the agents can participate
my lord,
in the second tender.
My lord, the bid, lordship, the differentiation is in
Because then it will never be a competitive bidding.
by say competitive bidding, my lord. Only classification is that, my lord, condition also there, my lord. Here only we have made little bit more, my lord. Because it's a time bound program. 20 days is the time limit. It is not that totally absent is there, my lord. No.
No, if it is, if you are producing, if you are procuring it only from a dealer, it would always mean, let us say, for example, a car, company X car.
No,
You have to get it from the authorized dealer.
No, my lord, that is not, my lord. There's lots of company who produce the particular, suppose in Gujarat, in Andhra Pradesh, or so many, my lord, states are there.
That's okay, just show me that,
The participation
participation is restricted to authorized dealer only.
No, no authorized dealer, my say company, my lord.
130, 130 in the second NIT, page 130, your lordship will get the bidders eligibility. The manufacturer, authorized dealer, and authorized importer.
This is condition not here, my lord.
I am referring to the second tender.
Exactly. Now let us see this classification, my lord. Now I'm coming to this eligibility, lordship, page 36.
Same thing.
Yes, ma'am.
Exactly same.
But the basic, my lord, the substantial situation is that, my lord, we want to make more secure because time is a factor, my lord. And in case of these two, my lord, that the 20 days time is not a factor, my lord. That will be continue entire session, my lord. Rabi, as much as man Karif, my lord, session. The purchaser is the best my lord, person to judge that what condition will secure the, my lord, successful process. Now, till that, my lord, they have not participated the process, my lord. Why they are sitting silent, my lord, over this, my lord, last more than, my lord, 1 month, my lord. The other, my lord, can we see that?
Mr. Chaudhary, where are the documents which are to be submitted along with the tender?
My lord,
Where are the list of documents to be submitted along with the tender?
My lord, that contain,
list of documents, my lord, I'll just check.
my lord, the page 37.
27. No, where are the bidding documents? These are the documents which are contents of the, it's a content of bidding
My lord,
documents. Where are the documents to be
my
submitted?
lord, my lord, I'm. My lord, may I look, lordship, page 39, my lord. Technical bit. My lord, can you see manufacture
just one,
operation letter?
just one.
Page 39, your lordship will get the documents comprising of the technical bill. Page 39.
Documents are almost similar, my lord. I have gone through, my lord. Almost. There is no need denial to that fact. Only thing is my time bound program, my lord.
Both are time bound. When it sees, both are time bound. Mr. Chaudhary, what according to you is your turnover?
We have not, my lord, stated those turnovers, my lord. We have not stated, but my lord, that does not meet the requirement. That's why I am before your lordship. The 20% requirement and the, my lord, 5 years of experience, that does not, we do not meet that.
What is the estimated value of the contract?
My lord,
Item wise, just an average. It will be
as per my info, 6 crores something, my lord, per, my lord. Yeah.
per item, it will be over 6
There are
crore.
31 items, my different items, suppose procurement.
Every 6 crore per item.
Like that, my lord. Because, my lord, it's a scheme. Different sheets are there, lords, that contain in page, my lord, figures are my quantity and price.
So what is the quantity?
My lord, page 66,
66,
schedule of requirement.
6, quantity in quintals.
My lord. And my lord, prices are incorporated in the basic price which they have to put. Start from page 63, my lord.
63.
What are the difference between here and lordship? You will explain everything in our affidavit, my lord.
Yes, sir.
It's a very technical issue, my lord.
We have a very handy university here. By the time you'll find instructions, I already have. I have opened up the seed standards.
Okay, my lord.
So that in Indian standards for seeds, I have it opened.
My lord.
Therefore,
My lord, Indian Seeds Act governs the my lord, certification.
pardon me.
Indian Seeds Act, 1966.
No, there's a Indian minimum seed certification standards.
My lord. And there's an office
So,
also, my lord.
here in this contract, when I read that it has to be certified, I just wanted to know what the certification is, and therefore I opened this up, and the standards is there. And the standards for different varieties. If it is that certified, it has to have a blue tag. Just like for vegetable, we have green tag. Now it is blue tag here. So I just checked out while you were submitting. I was reading that. There is another portal in the net which is called Vikaspedia. Vikaspedia. There, I'll just show it to you. You will come to know what I was reading. It was Dasji.
But ultimately, the certificate has to be issued either by the central government or
Let
the
us see.
state government.
It's not there. I'm just at times I digress, and therefore it's a
Sorry.
There are 4 generally recognized classes of seeds: breeder seed, foundation seed, registered seed, and certified seed.
in the meantime I've read it.
Yes, ma'am. Breeder seed, foundation seed, registered seed, certified seed. The progeny of foundation seed produced with registered seed products.
It also has the channel. There's the pie chart showing how this has to be procured, how it has to be delivered. Everything is there. Next, if you scroll up, you'll find.
Certification is voluntary.
Manner of procurement and disbursement to the farmer. There's a chart given here.
Yes,
You
madam.
found that? Scroll up, you'll find it.
Producing agency, then breeder institute.
ICAR
Yes.
or government, and then it goes to the farmers of the government. So,
True.
and then down below you'll find that seed certification. There are two.
This chart, madam.
Below that, just below that, you'll find these two standards are there mentioned. Only two lines. Seed certification standard.
Right.
That also I checked up.
There, my lord, these are very, my lord, difficult terms, my lord, 98.0, whatever, my lord, these will not understand, my lord, that.
No, will not understand. That's why I said I qualified myself by saying that I am from commerce background, not the botany background, but part of botany I was trying to read and understand.
Okay.
Lordship, my substantive submission only stand on my lord.
Just something more I'm trying to find out. Just 2 minutes.
Yeah.
1 quintal is 100 kgs.
Yes. 1 quintal to 100 kgs. 100 kgs. Yok, liman var.
Mr. Chaudhary, the requirement of 20% will not be high. What is the reason to say so? I don't know the rates of the items. I just checked up one item at page 66. That is black gram. Quantity required is 19,000 quintals. In the net average price of 1 kg of black gram seeds is reflecting as a cost of 180 rupees. So if it is 180 rupees, then 19 quintals will cost 34 crore 20 lakh. So a requirement of security of 20% of 6 crore
68 crores.
will be
Minimal.
64 is 1 crore 20. And it will not be much.
20%, man.
20% of 6 crore
Particular items.
is 1 crore 20 lakh.
20% of a particular item.
Of
One
a
item,
particular
my lord,
item.
one may qualify, but there are many items. That's why, my lord, we
Quantity,
cannot-
because you must have your liquidity of 34 crore rupees to make a supply within 2 months.
My lord, 1 month, my lord, 20 days.
20 days.
20 days. Even not 20 days because my
No,
lord,
for
that
one item I may have, my lord. But my lord, tender is not for only one item.
No, I understand, but it says the condition is that you must have cumulative, what do you call, capacity of paying this security.
But that condition is not there in the other two contracts, my lord.
No, may not be, but we can't say which is right or wrong. If but if one item is 34 crore, it will be a
There
huge
are
amount
31
of
items, my lord.
21 item. Even if we say it is 5 crore each, 5 crore each into 20 would be 100 crore. So requirement of security of that amount may not be
No, my
incorrect.
lord, the party may not participate in all the, my lord, 21 items. But then, my lord, they cannot limit it to, my lord, one item. That is a restriction. And for that, my lord, bank guarantee provision is there in the other two NITs. And it's not that, my lord, I am not supplying to them that I am a blacklisted contractor. No, now, my lord, the experience will be with regard to, since your lordship has given this black gram is an example, my lord. I must have that experience of supplying black gram for the last 5 years. That restricts me, my lord, even if I, my lord, fulfill the financial, the requirement. Added to that is the 5 years experience. I may have experience in other items, but I may not have experience in that particular item.
No, that may not be correct. Page 64, you see page 64, you see the bidder must have an average turnover of so and so, doesn't say a particular item.
no, my lord, items, all items, I guess each group product. Line is
No,
very
that
much.
is security. That is annual turnover. 20% of quantity of the item of schedule during last financial year ending from any business.
My lord,
Any business does not mean that business.
my
only.
lord, exactly.
Page 64, 4.2.2.
Last line. It's a normal, my lord, that any business requires just to satisfy that, yes, he has a capability, my lord. Simple, that is the test.
You have an average turnover of rupees so and so as the quantity of items during last financial year ending on so and so from any business.
Well,
yes.
So you may be a textile trader.
I am, my lord.
No, I'm just,
Yes.
you're saying you may be a textile trader, but if you have a turnover of
No,
6
I mean-
crore 42, you are entitled to give a supply. So it doesn't restrict you to that item only. So then it
Well,
would not,
it says the bidder should have at least an average annual turnover of rupees such and such 20% of the quantity for the schedule of item
Against
during the
each
last
crop.
3 financial years. So
from
20
any business. It doesn't say you can supply, what you call,
against each crop.
that is the quantification of a turnover, 20% from any business. So you may be a textile trader. You may not have an experience in supplying seeds. So with that condition, it's not. it
Then,
doesn't-
my lord, this is contrary to the requirement of experience.
Where is that experience? Where is that experience?
Experience
from?
is at my lord, page 63. The bidder must have experience in supplying certified seeds to the government departments, undertaking PSUs to the extent of 20% of the estimated quantity. If my lord,
Against each particular crop.
yes, my lord. Then, my lord, I may be a builder. And my lord, I will not have the experience. I may meet the requirement of the financial capability.
Lordship, may I make the position clear, my lord? Lordship, just hold for a moment, 64 page. It says out of item, my lord, not my lord, other business.
No, but again, 2 is contradictory.
No, my lord, kindly, just look for me, 4.2.2, for a moment, my lord.
I have read it.
My lord, here says the bidder should have at least an average annual turnover of rupee mentioned in the table below 20% of the quantity for the schedule items. That is against each crop, not other business, my lord. The crop which they want to deal with, my lord.
That is for the purpose of average turnover.
Yes, my lord. But that pertain to crops, my lord.
No, can't be.
Kindly see, my lord.
You read it. I have read it.
I may be wrong, my lord, but
Before I'm making that statement, I have read it several times.
my lord, lordship,
Read it.
my lord. The bidders should have at least an average annual turnover of rupees as mentioned in the table below. This is 20% of the quantity for the schedule of item against each crop. During the last 3 years, financial years also, from any business, my lord, out of this, my lord, schedule 27, if he deals with any item, my lord, no problem. Out of 27 item, schedule item, if he deals with
That can't be read. That can't be read. There's no way that can be read. Any business means any business. That's why I said you can be a textile merchant. You must have a turnover of 20% of the item you are bidding. If the item is 10 crore, 20% of
2 crore
is 2 crore, you must have an annual turnover of 2 crore from any business. I can't read anything else.
Anyway, my lord, so far financial is concerned.
But then this 4.2.1,
Yes,
2 is contradictory. It can't be saved. 2 can't stand together.
Yes, no doubt, my lordship, that it must be in consonance with my lord 4.2, but lordship 4.2.2 against the same line is there and same line is there also.
No. It's totally different. Please read it. Read and then say. Please read it. I have spent some time
Quite right,
reading it.
my lord, page 63,
4.2.1.2.
Yes, the bidder must lordship, prior to the lordship, may I read one, my lord? This is also my lord, important. The bidder must have experience of supplying certified seeds to the government department undertaking entities PSU to the extent at least 20% estimated quantity for this schedule of item against each particular crop in the certified seeds business during so and so, my lord. The bidder participating for multiple items should not exceed to the total quantity of supply experience in supply of certified seed during years mentioned above. Now, the bidder must have experience of supply in TLCs to the government undertaking to the extent at 20% of the estimated quantity of schedule item against each particular crop.
So therefore, your experience and the requirement are totally different. Now this is restrictive clause. That means now you are designing your tender to restrain competition. He may have a turnover of any business.
My lord.
But when it comes to supply, then you have to show that for every item he has supplied 20%.
No, not my lord, any business, my lord, that means out of 27, lordship, I may be wrong, my lord, subject to lordship, I will reserve my lord, prayer. 4.2.2 says, my lord, the length, if we read from top.
So therefore, if I am supplying tomato,
my lord,
I don't have experience in supplying carrot, then I can't apply for carrot.
No, my lord, that is not there, my lord. It says, my lord, kindly, lordship, if lordship.
You see, I can bear with you, but I have my limitations.
Absolutely, quite right. I may be wrong, my lord.
There's a long board.
Lordship, I may
There's a long board.
Lordship, any business means 27 item. If he has any eligibility to deal with of 20%. Other than mal, if he's mal apply for any other product, mal, he's eligible. Mal.
Okay, we accept your submission. Let us say these things I understand and I eat. I am relying on two, tomatoes and carrots.
My lord.
So therefore, if he has experience in supplying carrots,
My lord.
he can have a business of tomato and have a what you call annual turnover of 6 crore generated.
My lord.
So he has that 4.2.2, correct? That's what you are
Yes,
saying.
my lord, because any business is there.
That's what you are saying.
My lord.
Okay, now come to 4.2.1.
My lord.
Now it says that you can only supply those items where you have an experience of supplying 20%.
My lord.
So when we come to the same example of tomato and carrots, supplying of experience of tomatoes will not entitle him to bid for carrots.
My lord, here is a lane, my lord. Definitely, my lord,
read, I read it.
my lord, it may not be because once, my lord, he experienced, my lord, gain the experience. Definitely, he deal with a particular item which is suppose deal with the my lord, financial as much as my lord, it automatically comes. Otherwise, my lord, experience part. It cannot be two, my lord. Once I supply, suppose carrot, my lord, for 5 years, suppose, my lord, taking that way, then automatically it gain the my lord, financial criteria also, my lord.
I don't know. You are,
Well, I will
your
make
department is wise. You purchase seeds which are certified.
Well.
So if I am a book supplier, you will say that you will only supply book where you have experience of supplying 2 books. So if I am a bookseller, I sell this book, Motor Vehicles Act, only 1 piece.
Well.
I can't sell it to the government. I will have to say that these rules I have supplied 10 will not qualify me to supply you books of what you call Motor Vehicles Act.
Well.
What is this? It does not say that you don't have an experience of growing rice, you can't grow wheat.
The thing is, my lord, with my limited my lord knowledge.
It's anti what you call competitive. It can't be. I am seller of books. Then you give a quantity, then you are a seller of books, that is okay. But out of 2 books, you must supply both the books, 20%. I don't print the books. I get it from Universal. You also get it from Universal. Mr. Chaudhary also gets it. Chaudhary too. He gets books from Universal, and then you say that okay, in Universal, if you don't sell book X, you can't supply Y.
Well.
Or if you don't have experience in selling X, 20% turnover, you can't show. You can't sell that book. What is that?
But anyway, my lord, that so far these 2 conditions are there, my lord. He himself said, my lord, that
No, you
they
take
are-
his, you take his bid. You take his
They are-
bid. That not be a disqualification for him to, you to expect the bid. If you want to give a bank guarantee, say.
My lord, I want to give only one reply, my lord, regarding the, my lord, the submission of my learned friend that, my lord, we have come late. My lord, the last corrigendum was
You are
issued.
in this matter?
Yes, I am in this matter.
Okay.
Challenging the tender, the same tender, but I'll be bit of different with Mr. Chaudhary. I am challenging the corrigendum. The third corrigendum I am
16-4, my lord.
16-4, I am challenging the
Oh,
corrigendum.
let me just.
Yes, that's why I'm saying before passing an order, please
Okay.
hear me, my lord.
Okay.
Here, my case is opposite to the read petition of mine. I am challenging the corrigendum.
Okay.
That's why, yes.
Okay. Okay.
Now, lordship, my humble praise at this moment, my lord, the process is ongoing. If lordship feels that this condition otherwise to be, my lord, altered by way of bank guarantee, whatever, but lordship, that process may not be, my lord.
The process we are not
my lord.
interfering. We will not interfere, but we
Lordship
Mr.
wants
Das
that
for his
arrangement
case.
to be made, my lord.
What Mr. Das says, we say.
Now, lordship, I think this
No,
is.
regarding that, my lord, that we have come late. The last corrigendum was issued on, my lord, 16/4/2024. And there was a pre-bid meeting. And my lord, there has been certain clarifications. I'd like to take your lordship to that clarification also of the
Where is
bid
that?
committee, my lord.
Where is that?
That your lordship will find at page 118.
118.
Yes.
Yes, it's there. I opened it up.
In fact, my lord, it starts at 117. Minus of the departmental bid committee meeting held on 10/4/2024. And my lord, there your lordship will find page 118, your lordship will find 4.2.1. Clarification has been given, my lord. Experience to be counted from any seed business instead of certified and truthfully labeled seeds against the estimated quantity of scheduled item.
You're reading where?
my lord, page 118,
Yes.
serial number 3,
3. Yes.
regarding clause number 4.2.1. Experience to be counted from any seat business instead of certified and truthfully leveled seats against the estimated quantity of schedule of item from the last 3 years. Now, my lord, this was raised, and that's why, my lord, the bid committee, they discussed it. Now, the right-hand column is the, my lord, their comments of the bid committee. No change. In case of certified seats, government notified certified agencies certify the seats of the growers registered with them and considering the technical aspect, norms, and through different processes. But for truthfully leveled seats, it is leveled against as truthfully, not certified. Similarly, in case of hybrid seats, process is also different, so it cannot be treated as similar items. That is what they say, my lord. And this is the last, my lord, corrigan down, and therefore, my lord, they cannot say that, my lord, we have come late. Although my lord, the NIT was issued only 8th of March, last corrigendum 16th of April, and the last date is, my lord, 2nd of May. How can they ascribe, my lord, the delay on our part?
My lord,
No,
this
but
is
this
new.
serial number 3, I don't find it wrong. There are reasons, we'll come to it.
No, my lord, that's all right, my lord. What I mean to
No,
say,
but what about this, what do you call this? Turnover.
they're showing the, my lord, what is the difference between the, my lord, certified seats and truthfully labeled. It should be labeled, my lord, truthfully labeled.
It's a spelling mistake, I have noticed that.
That is the difference according to them.
But you did not raise that plea that you have experience in one, you can't supply other. That is something which is not raised.
No, the question raised was experience to be counted from any
Any
seat.
seed business. The any seed business was not there.
Yes. That
So
was the,
it has to be of the same
Yes.
variety. But in same variety, I was just giving that
That's why,
example
my
of
lord, it was raised that, my lord, it should be from any variety, and that was, my lord, rejected.
no, any variety is different from any item of that variety. If you
Any
come to
item of
certified
that-
seeds and take the same example of a tomato and a carrot,
Yes,
so
any item. My lord. In fact,
any item of that variety,
Yes.
that's why you should not raise there. Okay.
Now, Lordship, I make the position clear that why, my lord, there is a delay, my lord. The reason which has been assigned is not sustainable because, my lord, conditions are already there at 8/3/2024 about this too. Only thing is that, my lord, by this corrigendum, my lord, we have reduced the condition of experience and, my lord, the eligibility criteria for financial because, my lord, earlier we have formulated these two conditions based on, my lord, the quantity of supply, my lord. Subsequently, what happened, my lord, the government of India, my lord, reduced the quantity for, my lord, supply and funding, my lord. That's why, my lord, in comparison of the reduction of quantity, my lord, the two condition has been also reduced, otherwise it become more flexible, my lord. It will not hamper them or it will, my lord, not cause any prejudice to them, my lord. Kindly see, my lord, for a moment, page 118, one clause only, my lord. The justification, page
Just a moment.
118, 4.2.1.
Just a moment. I may not say it in open court. Look at this, Raji. Ah. No, it's okay. You can both look at it. You can peep. Mr. Jamali, you can peep. These are only 3 companies who can supply that amount of that quantification of seeds.
My lord. My lord.
That 45 is my submission.
It appears so. I have a bad habit of cross checking.
No, Lordship,
My submission.
No, you also see that. Sorry,
So therefore, my lord, my submission will let them come with a, my lord, with their stand within whatever earliest possible time. And they cannot, my lord, say that, my lord, because of this delay 20 days.
Now you see, I have gone to minimum. My calculation was 5 crore per item. 27 items are there. We took it's easy for calculation. So I took 20 items, is 100 crore.
Yes, my estimated, my lord.
Just an estimate, 5 crore into 20 is
My
100
lord.
crore. So therefore I found out
Rough
companies of 100 crore worth.
Now, Lordship, may I address only one point very important, 118, Lordship, kindly see for a moment that why this corrigendum has taken place, madam. 118, madam. 118, column 1, serial number 1. And
No,
my
but
lord,
it's-
response
you
to
see,
the-
the reason why I'm showing you this is, if I'm showing you this, your 2017 Act is gone for a 6er. Is a government act of 2017. If this is not restrictive, what else would be? You take your time. By the time Mr. Das makes a submission, you think over and tell us if only 3 participants can be expected. Is it compliance of 2017 Act? There's a question if I put to myself, what would the answer?
And also, my lord, public procurement.
You can go out, call the people and just have an idea. In the meantime, I'll hear Mr. Das.
My
By the time you take instructions.
Well,
you
I'm also here, madam.
You also, you can find out to the Procurement Act of 2017. That in mind.
বেঞ্চ মানে হচ্ছে এটি বেঞ্চ 4 মেজার হিসেবে রেজিস্টার হয়েছে 5 স্যার এটা রাতিপুৱা অনুযায়ী 5 গুলি লিখাৰ কাৰণে আমাৰ এখানে একটা আপুনি দিব লাগিব
Just a clarification. This matter is a bench 4 matter or 5 matter?
It's a, I don't know that. Normally this type of.
But this type of matter normally dealt with my bench 4 tender matter. It was.
You know, because an objection has come, my court master is pointing me out.
They have some failure. Yeah.
Mr. Chaudhary, this matter is to go to bench 4. For some reason has flagged this.
Actually, when I mentioned in the morning, it came up before this bench. Then again withdraw with the liberty to file. It went before bench 4. bench 4. I was there, sitting there. Now, I think that was discussed with the learned judge. Learned judge says that,
Just now the registry has flagged this item.
learned judge said that let it go before that bench. Yes, I was in that court itself.
Okay,
Production list came in that bench.
it came.
It came, but I think learned single just said, as this matter is pending here, so let it go before this
Somehow
bench.
the registry has flagged this item, just now he has got a message.
We understood it to be, my lord, bench 5, otherwise there is no reason.
No, but it has been flagged by the registry.
After too much of
Tomorrow.
deliberation, my lord.
But my lord, let us
But since the registry has flagged it for some reason,
my lord,
they will have good reasons to do it. Otherwise it is bench 4.
Tomorrow is the last day.
But 5 o'clock is the last day tomorrow. That's the whole problem. I also want that this should not proceed.
Listed tomorrow morning.
Maybe we have a difference, but I also don't want that this should be proceeded. I also want that they should not proceed. That's the whole problem because
We make it. We tell the registry. Tomorrow morning it will
Madam.
be listed in supplementary.
yes, my the first item that can be taken care of, my lord, no problem.
We can make a. Let's. This one is the registry has flagged it. That's why he has.
My lord.
My lord, it can be helped, my lord. It can be helped, my lord, lot of.
My lord, their delay also, my lord, their approach is also very much delayed.
no, there is no question of delay. What delay, my lord? That's what they have last moment.
Court will take up the matter.
No, I'm saying corrigendum issued and we have come against the.
Any of them.
That's one thing. Very last.
Taken a view.
My lord, what has happened? No, I was before that court. A
This is
production
Michael,
list
I
came.
told, we have received all the information. This is
Yeah,
Michael.
that's why he said that let it go before.
No,
This
but
is what
it-
I have said.
No, but it can't be taken up. That's why the
Madam.
the registry is flagged.
Yeah.
But-
I'm just told, I'm aware that it came before the bench of honorable justice Michael.
That's why I said I was sitting there. Production list came, but as this matter is being taken up, so the honorable judge said, let it go before that bench.
No, I
That's what-
understand, but somehow it has been flagged for some reason. This is
Another
a,
difficulty, maybe, my lord, tomorrow there is a full bench where Honorable Justice Michael will also be there.
that is in the second half.
In the second half, my lord. The
Let it-
time tomorrow's,
That is in the second half.
yes.
What is harm, my lord, if first item would be taken as a, my lord,
No, we'll get it listed
Yes,
tomorrow
madam.
morning. Please, we'll
one day
make
they
a
can
mention.
wait, my lord.
We'll make a mention.
This, in fact,
This-
the procedures are handmaids of justice, my lord. In fact, your lordship is,
Otherwise, they would not have flagged it.
yes.
Message has come to him, that means somebody has flagged it.
Right.
Uh,
Anyway,
this all sides, including the senior counsel for the petitioners are present. It's the matter being a bench 4 matter. Let the matter be listed before the appropriate bench. Next para. The senior counsel for the petitioner has expressed some urgency in the matter as the tender is scheduled to be opened on 2/5/2020.
submission is, my
My
lord,
lord,
submission is.
Oh,
Last
last
date
date
of
of submission
Submission.
is 2/4/24 and 2/5/2024 and the bids would be open on 3/5/2024. Full stop. Under next para, under such circumstances, the registry is directed to list the matter on 2/5/2024. Next para, liberty is granted to the senior counsel for the petitioner to pay for updating the matter.
How nice.
Biblios.
Mr. Chaudhary and Mr. Das, I'm sorry.
That's.
But we have gained a lot of experience, my lord.
No. You see, we learn from you only. It's not that, I have a very bad habit of.
And
What's
lordship
it?
was gone into the entire situation of botany, my lord. This is a really nice thing to learn.
And you, if you have any grievance against that,
No, no, my lord, we learn, my lord.
you have to blame Mr. Das for it.
So many new facets, my lord, we have touched, my lord.
Production list item 1, WBC 2308/24.
But here in this case, my lord, is a my lord eviction proceeding, my lord, initiated, my lord, by the circle officer, Mankato Revenue Circle, my lord, without any notice to the petitioner, my lord.
Just. You have an extra photograph of the shop?
My lord, photographs, my lord, of the shop has not been annexed, but the trade license have been annexed, my lord. And the photographs also, my lord, I could not print out, but photographs are in the in the mobile, my lord. So initially, the eviction notice was issued, my lord. In compliance with the eviction notice, my lord, I have complied with the eviction notice. Then subsequently, my lord, I met two representatives.
No, you are not, you see, because you are not entitled to protection. As it appears from page 19.
My lord.
Come to page 19.
Page 19, my lord.
Yes.
This is
You are,
the-
you are illegally encroached by construction shop in both sides of HM Road.
My lord.
So on road, we can't permit you, the eviction has to be carried out if you are on road.
No, no, my lord. I have complied with this eviction, with this notice, my lord. As per this notice, my lord, I vacated my shop. Subsequently, my lord, I made a representation before the district commissioner to allot a suitable place for establishing my shop, my lord. Then, my lord, within a week, my lord, the district commissioner office and the revenue circle office, my lord, they made a spot inquiry and, my lord, allotted a small plot of land in a pit area, my lord. Then, my lord, I developed the land and constructed my shop, my lord. And for more than 1 month, my lord, I am running my shop, my lord. The land has been allotted by district administration.
Where is that document?
My lord, verbal by my lord, this is my statement, my lord, supported by evidence, my lord. No written order has been written order was given, my lord. Only a revenue officer came, they, my lord, measured the land and they allotted, my lord.
Where?
My lord, they have verbally done, my lord.
No, but where? Where is the location?
My lord, it is in front of the district commissioner office and far away from the road, my lord. It's a very pit area. It's a deep pit area, my lord. I fill up the land.
We give you time if till 4:15 you can produce a photograph of the shop showing us the location.
Yes, my lord, within 30 minutes, my lord, I can do this.
Show us the location of the shop so that I can understand what is in the locality.
Far away from the road, my lord. And it is.
We don't know, just show us from the roadside, we must know where that place is.
Yes, my lord. Otherwise, my lord, I have complied with this eviction notice. I have vacated my shop, my lord. Subsequent, my lord, this is subsequent development, my lord. This land has been allotted by department, my lord. And on the basis of this allotment, although it is a verbal allotment, my lord, I fill up the land. It is a very
No,
deep pit
Mr.
land.
Swami, it doesn't carry a meaning to me.
My lord.
The reason being, if there's a land allotment, it has to be done by the government, not by the deputy commissioner. He is incompetent to allot land.
In fact, my lord, para 4 is waiting on as matter of record, my lord. So I don't find any order or something like that.
I don't know. That's why we are giving him time. You can show it from the mobile, get a photograph.
Within 30 minutes, my lord, I'll put.
When you are ready, tell the court master, we'll take it up.
Lordship. And I'll bring the photograph.
Item 20.
May please, your lordship. My lord, this IA is filed for, my lord, implement of finance department as a party to this petition, my lord.
Thank you.
My lord, the matter relating to the, my lord, the 5% balance amount of construction work, my lord.
Permit this.
Your Lordship, I'm appearing on behalf of Ms. R. S. Dewey, Your Lordship, for the Soil Department. Your Lordship, we have no objection to the it.
Mr. M. Islam, counsel for the petitioner, applicant. And Mr. D.S. Dekaranan, counsel appearing on behalf of Mr. R. S. Deori, standing counsel for the Soil Conservation Department. Appearing for all the respondents. Next one is, by this interlocutory application, the applicant seeks to impede the Commissioner and Secretary to the Government of Assam, Department of Finance. Post one. Mr. Islam, we have a standing counsel. Why you don't serve copies to him? Because without hearing the finance, we can't pass an order. Yes. We try to catch hold of his standing counsel for finance and come again. We have a standing counsel. We can't pass ex parte order with his finance.
Yes, sir.
Try to find them.
And you have left, Your Lordship. Much of it.
21.
May I
Yes.
please, Your Lordship? Lordship, in this case, Lordship, we have challenged the adjudication order, which Your Lordship will find at page 145. 5/7/2022.
No, here we have an IA district to that. Why is
Lordship,
this?
Lordship, that is why I'm explaining.
Ah.
Lordship, one is for implement, one is for stay. Lordship may kindly see page 160 of this order, adjudication order. Lordship,
Any
what had
objection in this application for impleading?
Implementing, I have not.
Okay.
Lordship, what had happened in this case? Lordship, so was
Oh,
noted.
one by one. If we are passing orders here, then come to the next
Yes,
one.
Lordship. First, implement.
Uh,
1193.
Heard Miss Anne Haveliel and counsel for the applicant. And Mr. S.C. Kyalan and standing counsel for the CGST appearing for all the respondents. Next one. By filing this interlocutory application, the applicant is seeking implement of the Assistant Commissioner within bracket capital TAR bracket closed, CGST as respondent number 4. The next paragraph, the said prayer having not been objected to stands allowed, and the said authority is permitted to be implemented as respondent number 4 in the connected petition. Next paragraph, the main case. The petitioner and respondent. In view of order passed today in IS Civil 1193 of 2024, the learned counsel for the petitioner shall provide a amended cost title allowing implement of a party as responsible for the counsel for the petitioner shall provide a type copy of the new cost title to the AOJ civil rule pending section. Will incorporate the same in the writ petition and cause necessary correction in the central registry. Yes, now second IA.
Lordship, that is for the Lordship, stay of some recovery notice has been sent during the pendency of the writ petition. Lordship, I was just explaining what is the writ petition, Lordship. In very short, Lordship may kindly see page 160 of the writ petition.
Yes. One
160, Lordship.
160.
Lordship, paragraph 10. Lordship, before explaining paragraph 10, Lordship, a so-called.
Yes.
Lordship, a so-called notice was given to me. And Lordship, there was a Lordship suspicion that I have to pay a amount of rupees 1 crore 44 lakhs. Lordship, thereafter, this is the finding after hearing me on so-called notice at paragraph 10. The service tax liability, Lordship, of the noticee during the financial year 2016-17. This is the period, Lordship, 2016-17 relating to service tax, Lordship. Against the various services rendered is summarized as under. Lordship will see that the services which I have done is the chart is given. What is the gross receipt and what is the service tax liability will be levied on me after hearing me. This is the figure, Lordship, has been determined by the service tax authority. Thereafter, Lordship will kindly see page paragraph 10.2. Paragraph 10.2.
Just one.
Yes, Your Lordship.
Yes, page
Lordship. Next page, Lordship.
10.2.
Page 10.2, Lordship.
Yes.
So Lordship had already seen that there is the liability which they have determined is 72 lakhs after hearing me. Lordship 10.2, Lordship says that what is the payment I have made. The noticee has deposited service tax amounting to 73,20,352 and interest amounting to so-and-so into the government exchequer under the following challans for during the financial year 2016-17, but did not file their periodic ST3 returns. The amount is liable to be appropriated in the government exchequer. So Lordship, there is a challan which is given. In the year 2017 itself, I had made the entire payment. Lordship, the amount which was determined was 72 lakh, but I have paid 73 lakh. And along with the interest, there was some delay in payment. So I have paid the interest. So everything was paid in the year 2017 itself. But Lordship, that says service tax, there is a return which has been prescribed to be filed. So service tax return, Lordship.
You see, that much we have understood. That's why we gave an interim order.
Yes, Your Lordship.
Correct. So
Lordship.
no point repeating it again.
No,
Once
Your
there's
Lordship.
something is there in my order, I would know under what background I'm passing this the order.
Lordship.
Now, why is this application filed? Just tell us that.
Lordship, then I will take Lordship directly to the Lordship affidavit that they have filed and then to my petition. Affidavit, Lordship, that they have filed.
Yes.
Page, Lordship, paragraph 11, page 168 of their affidavit.
Yes.
Lordship, that with regards to the statement made in paragraph 24 of writ petition in the answer reporting states that in order in original interest was confirmed, but it was already paid by the petitioner and so amount of interest was appropriated. Petitioner did not require paying any more amount as interest. Issue of levy of interest has been settled. Even Lordship, tax has been settled because everything has been paid. Only penalty remains now. Lordship, the notice of recovery which has been sent now, which I have challenged before this honorable court by way of IA number 1192, Lordship, page 15 of my IA. Now,
That is the reason I'm asking that question. You see, that's why that's the point why I wanted you to make. You see, in a writ petition, if you don't challenge that order, can in an interlocutory application I grant a stay?
no, Your Lordship, it's just a recovery notice.
You see, it's a query I'm making. There may be difficulty in my understanding, but the question we are trying to ask and understand
Yes, Your Lordship.
is that without a challenge to the order,
Yes, Your Lordship.
can we stay it?
No, Your Lordship. The challenge was there and there is a stay order which has been passed.
So you'll have to file a fresh writ petition.
But Lordship, this is not an order, this is a notice of recovery of that amount which was
No, that we don't know. We are not, you see, we are not commenting whether this writ petition we were filing will be maintainable or not. But the query is that if a demand is made or whatever notice is issued to you,
for recovery
if
of
I
this
have to,
amount.
if I have to stay it,
Yes, Your Lordship.
the question I'm posing to you is for the third time is, can I pass a stay order without the challenge being there? Because the interim interrogatory relief must be in furtherance to the main relief.
Lordship, let me examine this issue. And Lordship may fix this matters on some other day. I will examine this issue because this is the recovery of the same amount. So let me, Lordship, examine this matter, Lordship.
We just adjourn it
Yes, Your Lordship.
after 1 week?
Not after one.
Okay.
I will examine this matter and Lordship come before Your Lordship. Either we'll file a writ petition or.
Okay. List after, both sides are represented, list after a week is fixed by the then counsel for the petitioner.
Much obliged. So the main writ petition, the interim may continue.
Okay. The main petition, second IE, the petition of interim order passengers transaction day, list after a week.
Item 20.
Same thing, training, we implement them. Mr. Shadia, A. Shadia, and Shanikazi for the finance department, which is no objection to the prayer. The prayer is allowed. The Praise the Lord. The Commissioner and Secretary to the Department of Finance, Government of Assam, is allowed to be updated as respondent 4 in the connected WBC 3365 of 2022. See the main cost title change. You give a copy, recommended cost title to both of them. Pending the formalities of such implement, court is inclined to issue notice on the newly implemented respond number 4. The notice is made returnable in how much time? 4 weeks.
4 weeks.
4 weeks. Requisite extra copies of the requisition be served on the standing counsel for respond number 4 within 3 days. 3 working days. List after 4 weeks.
Highly obliged, Your Lordship.
Upgraded item 41 for orders.
Yes.
As against the order passed by this High Court in Order 7 application, we filed an SLP, and if Your Lordship permits, then this is the one basic feature of this judgment is we take a Lordship 1 minute time. All along, there was a gray area that non-disclosure of movables or immovables, which was held to be a corrupt practice of undue influence under Section 123, the legal fiction was created. The requirement of Section 83 regarding material facts, whether it is also is necessary or not. In this case, what happened? There was an allegation. Then the material facts, which already is settled long back, Azhar Hussain, Rajiv Gandhi, and all other cases, means when, how, in what manner, in which place. then first this has to come, then the material particulars like so and so, Mr. Ram, then he may expand it by saying Mr. Hori was also involved. These are the particulars. There is a line of demarcation. This is a case where the court has said that it cannot be section 83 referring to earlier decision was not done away with while bringing a legal fiction of corrupt practice of undue influence. The requirement of 83 of material facts was not done away with. So they're saying that the election petition did not contain those material facts. And in the last, ultimately, the Honorable Apex Court has dismissed the election petition.
I saw that.
Now, we come back to this court. There are 2-3 more requirements at now. In this election petition, there was a section 97 application for recrimination. Now, in view of the dismissal of the election petition, that there is no requirement to proceed with because only orders that can be passed by the High Court is under section 98. After declaring my election void, then it comes. So one order of your lordship may be necessary that recrimination petition in this situation cannot be proceeded with. Secondly is, since the election petition is dismissed, under section 103, there are certain requirements to be done by the registry, register judicial or that regarding sending of copies to the assembly, then the gazette notification, and these can be done only after a judicial order of your lordship under 103, directing the registry to comply with the procedures in terms of section 103 of the RPI. 103, my recollect. Let me see, let me check up for the section. 103,
But
my lord, come.
there's one good thing now.
My lord.
With this, I have not read it completely because I'll take some time to read it. But with what you are saying, it will be what you call very specialized art to draft an election petition.
My lord, it was in between that 2000, post 2002, more particularly after 2014 case, there was a gray area whether non-disclosure or of any thing, Parsi is this thing and nothing else need to be proved. Now that in this Honorable Apex Court has harmonized the earlier judgment and also those earlier judgments with the requirement of material facts was mandatory. So now it has been harmonized to say that that is a legal fiction. Now that does not absolve you from the requirement of 83.
Therefore, highly specialized knowledge.
My lord.
Highly specialized knowledge to now draft.
My lord, drafting is always a high specialized knowledge. So sometimes I do not know that days have changed.
Days have changed.
Days have changed. Even knowledge records, nothing is there. We just put paragraphs and it comes out as a petition. But it is always, I personally believe, should be a highly specialized subject. Because I remember one colleague of mine who was on this side and later on went to the other side. He belongs to our chamber. One day, now he is not there in the bench. He told me, my first duty is to check up the affidavit page, wherefrom he is swearing it. And then ultimately rest follows.
Many times I also do that.
That should be in fact.
That's why the last matter, Ms. Barman stood up and said about the affidavit. They are now catching up with that.
In one case, it's an important case regarding writ petition. It's a very limited scope, as your lordship is very much aware. They are in a compulsory retirement. And the affidavit, a person, an officer of 32 years, shown it from the personal knowledge, commenting on the long 30 years careers of the writ petitioner. That means he was 2 years old when this man joined, and he is swearing that affidavit that he is not good in service. He was avoiding, he is a man of 32 years, commenting on a personal knowledge when he was 2 years old.
103.
10, sorry, my lord. Let me check up. Yes, this communication has to be done pursuant to a judicial order by the registry.
Yes.
Possibly there will be two parts of your lordship order. First part is under 98D, I'm sorry, 98C. There will be no scope for the recrimination petitioner to proceed with his recrimination petition. Because first, my election has to be declared void. Then your lordship will proceed with the recrimination petition. Now that stage will never come now. So possibly there will be two parts of the lordship's order. One is,
Because this C
yes,
is referable to again 101.
101, my lord. Those things will not come in now, declaring the void. Had it been declared void in the election trial, then recrimination, so I personally feel there will be two parts of your lordship's order. One is the direction to the registry, and before that, there is no, otherwise it will be hanging.
But again, interesting question.
My lord.
Might be a incorrect question, but
Nothing,
it appears
nothing
to be.
incorrect come because lordship can ask me any questions.
You see, 98 says
Yes, my lord.
decision of the High Court at the conclusion of trial of the petition. So the Order 7, Rule 11 will be deemed to be a conclusion of trial because it is point is rejected. Rejected amounts to a decree.
My lord.
Rejection.
With your lordship's issuance of notice, the trial began in this RP Act. So, moment the trial started, we brought in Order 7. Now the trial has been brought to an end. This will be slightly different than the CPC procedure. Because trial here in the CPC, after the summon comes, then the person appears.
Or then it's not a decree.
My lord, it will be
It
will
will
be
not
an
be-
order dismissing.
Order dismissal.
Order
Will
dismissal.
not be decree. Okay. Yes.
Yes,
We
sir.
pass orders. Heard. Mr. K.P. Pathak, done as senior counsel. Assisted by Mr. I. Kalita, done counsel for the respondent. This will be an election petition. No, not an election petition. Election petition is not an election petition. And Mr.
N. M. Ajarbuya.
N.M. Mazurvia, learned counsel appearing for the. You are for the petitioner.
Petitioner of the election.
Petitioner. Next paragraph. The learned senior counsel for the respondent has produced a copy of judgment dated 8/4/2024 passed by the Supreme Court of India in Civil Appeal number 6282 of 2023. By the said judgment, this election petition was dismissed. Full stop. Next, the copy of the said judgment is made a part of record. Next para. the learned senior counsel for the respondent has referred to the provisions of section 103 of the Representation of the People Act, 1951, which is quoted below for the sake of convenience. 103. Next paragraph. Accordingly, it is submitted that the order of the conclusion of trial is required to be sent to the Speaker of the State Legislature as well as to the Election Commission. Authenticated copy. Authenticated copy. Post. Next paragraph. He has further submitted that notwithstanding that the dismissal of the election petition was made by the Supreme Court of India, the orders are required to be communicated to the concerned authorities. Next paragraph. Taking note of the dismissal of this election petition by the judgment of the Supreme Court of India as referred above, the prayer made by the learned senior counsel for the respondent, having not been objected to by the learned counsel for the petitioner, stands allowed. Next paragraph. That the authenticated copy of the judgment dated 8/4/2024 passed by the Supreme Court of India in civil appeal number 6282 of 2023 be sent to the Speaker of the Assam Legislative Assembly as well as to the Election Commission of India. Oh, sorry, State Election Commission.
No, it's a election commission only.
Election Commission, okay. Election
State
Commission.
and the state election commission as well. Because conduct is by the state election. And Election Commission of India gives a first notification.
Okay, the Election Commission of India as well as to the State Election Commission. It's called State Election Commission. What is the nomenclature? State Election Commission or State Election Officer?
State election officer, but there is a state election commission.
State
Election commission.
Is it commission? I don't know.
Are you sure? Sure. It is called Assam. What? More complicated. I'm told it is Assam State Election Commission.
Assam State Election Commission. Okay, Assam State Election Commission. Okay. According to this election petition is stands closed as per the order of the Supreme Court of India referred above. Now, reclamation petition number 1, REP 1. Now, it is on call for the recrimination petitioner. Full stop. How Mr. N.
Mazhar Bhuiyan.
N. M. Mazhar Bhuiyan, learned counsel for the opposite party number 1, within bracket election petitioner, in election petition 1 of 2021, and Mr. K.P. Pathak, learned senior counsel, assisted by Mr. I. Kalita, learned counsel for opposite party number 2 are present. None appears for the opposite party numbers 3 to 13. Next one. Same. Senior counsel for the respondent number 2 has produced a copy of judgment. So first that part will be same. Next part, accordingly, comma, it is submitted that unless the election petition succeeds by a declaration that the election of the returned candidate is void, comma, the recrimination petition cannot survive. Stop. It is submitted that as the Supreme Court of India has dismissed the corrected election petition, i.e. election petition 1 of 2023, comma, election 1 of 2021, comma, the recrimination petition would not survive, and therefore it prays to the prayer is made to close this said recrimination petition. Full stop. He's also referred to the provisions of section 101 of the Representation of the People Act, 1951, whereby it is expressly provided that after declaring the election of the returned candidate to be void, the declaration of the petitioner or other candidate to have been duly elected can be passed. Right. Stop. As the election petition is dismissed by the Supreme Court of India, comma, the cause of action to pass order for declaring any other candidate to have been duly elected cannot arise. Next paragraph. Accordingly, comma, he said Prayer made by the learned counsel, senior counsel for respond number 2, have not been objected to by the learned counsel for the respond number 1, the prayer stands allowed. Next one, resultantly, the recrimination petition would stand closed in view of rejection of the, dismissal of election petition 1 of 2021.
I have any
There's
indulgence?
one more thing. Any other IA standing shall be closed.
May I have an indulgence? Ma'am? That if there is your, if a lordship desires, there may be a specific direction to the registry to comply with the procedures contemplated under 103. If that direction is there, now it is for the registry to, on the judicial side, to comply with the procedure, if there is specific direction, number 1. Number 2, in the recrimination petition, today no one appears. Because your lordship might have said that I would not, have not said anything about the presence of the advocate. For the,
He's absent. Absent on call.
Might.
I have recorded that because since it's a dismissal for default is not an answer.
My lord.
They have dismissed it on merit.
Merit. And accordingly, all other IOs are closed.
Yes, that we have passed on. So only will incorporate 103. Other requirements of the main election petition, other requirements of section 103 of the Representative of the People Act shall also be complied with.
I'm obliged to it.
A huge relief.
My lord, for me also.
Item 22 for admission.
Yes, PMGAY benefit not given. Why?
Let's say we have filed our affidavit yesterday.
As you've seen that.
If you also kindly
What is the ground? Oh, your affidavit is not here on record.
yesterday they filed.
Let's say we have.
What is the ground taken?
They taken that we have, this is the.
What's the ground? What is it? Okay, let this be typed on record.
But only fact is, my lord, they have taken different stand now, my lord.
No, whatever,
Earlier-
we can't do anything unless that is on record.
Yes, my lord.
Both sides are represented. The affidavit in opposition filed by respondent number 6 is not on record. Let the same be typed with record. List on. Give it next Monday.
It will fix next week.
Fixing it next Monday.
Yes.
What I will do? Affidavit too.
Let's
23.
In this matter, my lord, sanction order from the Deputy Commissioner Office after verification of credential has been sent to the Revenue Department, my lord. Next one, my lord.
What is the status of that MSCT case?
I have no knowledge, my lord, regarding MSP case.
So you'll have to file an affidavit. Disclosure of MSCT. Mr. M. Hussain, learned counsel for the petitioner. Also, Mr. A. Bhattacharya, learned standing counsel for the Finance Department, and Ms. M. Burma, the government advocate appearing for the respondent numbers.
I pay for revenue only.
For revenue also. Okay, so you are for one and?
Only one.
Achha, for revenue department. Not. No, respond one and Bhavan for respond numbers 2 to 6. Next one. The learned government advocate has produced a copy of order dated 4/7/2023, indicating that sanction has been made for release of the fund of the government for ex gratia to the petitioner. Next paragraph. Be that as it may. Comma. Court finds that that although there's a road traffic accident involving a vehicle bearing registration number AS 17 capital C 0121, in view of the decision of the Supreme Court of India in the case of Reliance General Insurance Company versus so-and-so, same query. Affidavit by the petitioner to disclose the status of the claim, if any, made before the Motor Accident Claims Tribunal by any next of kin of the deceased shall be disclosed. Full stop. 2 weeks.
Actually, my lord, I have gone through the Sushil Sharma judgment, my lord. In this case, my lord, difference is, my lord, the mother of the claimant was died while he was serving in the government. She was a government servant, my lord. Accordingly, there was a Act of 2006, my lord. By this act, my lord, the financial assistance was provided. But in this case, my lord, he was not a government employee, my lord. And the ex gratia amount given, my lord, not as a right, my lord.
Ex gratia
Yes, my lord.
is not as a right.
Not as a right, my lord.
Then your reputation would not be maintainable if there is no right. Your reputation without there being an infringement of right or fundamental right can't be maintainable.
My lord, in the earlier occasion, that issue was raised, my lord, whether the double benefit will receive or got or not, my lord. Accordingly, my lord, in the earlier occasion, my lord, senior counsel Kian Chaudhary was engaged as a amicus curiae, my lord. Subsequently, my lord, the case was disposed of, my lord. But in the judgment, my lord, the hate issue not described, my lord, but the same case, series of matter was disposed of, my lord. How many cases was disposed of, my lord?
after hearing the senior counsel, my lord, Kian Chaudhary, my lord, but that is not reflected in the order, my lord. But in the order sheet of the case is available. And I am also there, my lord.
Okay.
And there is another judgment, my lord, of the Honorable Supreme Court, my lord, in the case of Surya Singh, my lord. Herein it is stated that, my lord, paragraph 38, my lord, it is thus now well settled that the award of compensation against the estate is an appropriate and effective remedy for redress of an established infringement of a fundamental right under Article 21 by a public servant. The quantum of compensation will, however, depend upon the facts and circumstances of each case. Award of such compensation by a public remedy will not come in the way of the aggrieved person claiming additional compensation in a civil court in the enforcement of private law remedy in tort. And the mallet the compensation received from the MSCT court is as a mallet private private law mallet as a from the tortfeasor mallet. Being a there was a contract between the insurance company and the owner of the vehicle, etc.
Okay.
And the Shashi Sharma case, my lord, subsequently also clarified by the Honorable Supreme Court, my lord, in the case of, my lord, National Insurance Company Limited, my lord, reported in 2020-11 SCC, my lord, 356, my lord.
Give it.
Shashi Sharma. 80 to clarify 8 to Virendra and others. In paragraph 18, my lord, paragraph 17, my lord.
Just a minute.
Legally not identified. Previously, but otherwise to be actually problem. The vehicle is identified. Speak to locally.
Public place of the tax.
No, 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 it is only for. That's all vehicle. That's the lesson. So the vehicle of everything.
তোমার যদি নভেম্বর ক্লারিফাই হয়েছে এইসব মানে নোটিফাই হয়েছে যেগুলো any of the category তোমার ভোটের নাম না এটা
Yes. Para 18.
Yes. Right.
Para 18.
Yes. Perhaps 17, 18.
In this Subhay Singh, which was the paragraphs?
Subhay Singh, my lord, paragraph 38 and 46, my lord. 31 also, my lord. 31, 38 and 46.
The High Court judgment, the reference to a motor accident case is not there.
My lord, right. High Court judgment, my lord. In the case of Sujit Nandi, my lord. Accident.
Motor accident case is not discussed.
Discuss, my lord, page 69, my lord.
69.
Yes, my lord. In the top, my lord. Second line, my lord. This is persons who died, killed in road traffic accidents.
No, no, no. Accident cases have not been referred to.
Oh, that is not referred.
It's not there. Then you say, after reference to this, be that as it may, in the case of Shenzhen, that dance, the question arises, full stop. Next one, the non-constant for the operational. By referring to the judgment in the case of National Insurance Company Limited versus Birender and others. 2020 11 SEC 356. This is number 1. Huh? Mr. Subhay Singh versus State of Haryana and others. 2006, 3 SCC 178. And judgment and order dated 11/2/2021, passed by the coordinate bench of this court in WBC 8815 of 2019, that's Sujit Nandi and another versus the state of Assam and others. I've submitted that the decision of the Supreme Court of India in the case of Reliance General Insurance Company Limited versus Shashi
There is
Sharma.
another.
Would not stand as a bar for the payment of.
There is another order, my lord, passed by this honorable court.
So give it together. After I start dictation, then you can give one dictation of the other.
Sorry, my lord. Where explained regarding ex gratia and other, my lord.
Where is the reference to motor accident case?
That is not clarified, but the regarding definition of ex gratia payment, etc. are explained, my lord. Page 9 and 10, my lord.
Okay. And this one, number 4. So that's something, the case of Shashi Sharma shall have no application. Argument is concluded, judgment is out.
Okay.
24.
In this case, my lord, what happened, the husband of the petitioner was missing, my lord, accordingly approached this honorable court, my lord. The order, my lord, at page 47. Accordingly, this honorable court directed the DLSA to pay compensation under the 2012 scheme, my lord. Accordingly, my lord, the page 53. Operative part, my lord, page 52 of this honorable court, my lord. Paragraph 13. And my lord, the DLS already passed an order, my lord, and direct entitled sum may be paid as per procedure, my lord. Although the order was passed in the year 2022, not yet paid.
Talgu, you're appealing for the
We have
finance.
received the instruction from the District Legal Services Authority. They say that there is no fund as of today, man.
Correct. Funds the government will have to place, otherwise they will not have funds.
Lordship and direct one. Lordship and direct.
The direction would be to the finance to place funds. Mr. M. Hussain and counsel for the petitioner. CEC is appearing. You are there.
I'm appearing on behalf of Mr. S. for responding.
Miss
Ms. B. Devi.
B. Devi, Leonard. Counsel appearing on behalf of Mr. R.K.D. Chaudhary.
S.P. Chaudhary.
Mr. S.P. Chaudhary. Leonard CEC for respondent number 1. For government who will appear, you'll be appearing for all.
Man. 2, 3,
2 to 7 then.
It's mine.
Mr. B.G. Talukdar, Senior Counsel assisted by Mr. P.K. Mehdi, Government Advocate, appearing for Respondent numbers 2 to 7. The husband of the petitioner, namely Yusuf, USUF Ali, went missing from 27/2012. And accordingly, Fakiragram PS case number 76 of 2016 under section 366 IPC was registered. Full stop. Thereafter, the petitioner had approached this court and by filing WPC 1858 of 2018, had paid for payment of ex gratia in terms of the Assam Victim Compensation Scheme, 2012. Accordingly, this court by order dated 11/2/2022 directed the District Legal Services Authority, Kokrajhar, Secretary, District Legal Services Authority, Kokrajhar, to examine the claim of the petitioner for victim compensation. Full stop. Thereafter, by order dated 21/3/2022, the Secretary, District Legal Services Authority found the petitioner to be entitled to revised victim compensation of ₹5 lakh. And passed on order in this connection in the proceedings of AVCM, page 53, number 7 of 2022. So, the case of the petitioner is that the Secretary, DLSC Kokrajhar, has informed that as the government of Assam has not released funds, the compensation to the petitioner could not be released. And hence this writ petition has been filed under Article 226 of the Constitution of India. Full stop. Next paragraph. In this case, notice of motion was issued by order dated 22/6/2023, but no response has been filed. Next paragraph. It is seen that pursuant to the order of this court dated 11/2/2022 in WPC 1858 of 2018, the Secretary District Legal Services Authority, Kokrajhar, has made an inquiry and found the petitioner to be entitled to ex gratia rupees 5 lakh. In terms of notification number 524 oblique 2015 oblique part PT oblique 190 within bracket capital ECF 3861 bracket closed dated 1/2/2019. Stop. Next paragraph. As the state respondents have not disputed that the husband of the petitioner was missing since 27/2012. And there's no challenge to the order dated 21/2/2022 passed by the Secretary, District Legal Services Authority, Kokrajhar in AVCM number 7 of 2022, the Commissioner Secretary to the Government of Assam, Finance Department is directed to place a fund of rupees 5 lakh at the disposal of the District Legal Services Authority, Kokrajhar, within a period of 6 weeks from the date of receipt of a copy of this order, a certified copy of this order. On such payment being released, the Secretary, DLSA, Kokrajhar shall release the compensation to the petitioner. 6 weeks we are granting. The proceed directions for those petitions stands disposed of since allowed the extent as indicated above.
Sorry to mention, my lord, item 42 is similar, my lord. The DLSA already passed the order in pursuance of the order of this one.
Just wait, let it reach.
Oh, bless.
Just wait.
Time being item production list, item 1.
I have brought the color photograph with you. Which will show the shop room is at the very far distance of the main road. And this photograph has been taken after the expansion of the road. Earlier on the both side of the road, there were shops and all the shops were vacated. And after that, at the back side of the shop, there is a colony of the officers colony. And at the other side, the office of the district commissioner.
Yes, you've seen this photograph?
No. But in future, if the authorities require this area for any public purpose, I will take it.
My lord,
There is no statement in your petition to that effect.
may I point out one thing? As per Rule 23 of the settlement rules, nothing in these rules shall entitle any person to obtain a lease in respect of land within 35 feet of the center line of a public road. As per his own
You make an inquiry, you are only stopping the eviction for in the next date of listing. You make an inquiry.
Lordship.
If he is found not entitled to give it that,
My
revision will be dismissed then.
The India representation, Lordship, may kindly see. Page,
Yes.
page 22, Lordship, 22 and 23 also, Lordship. The file representation before the deputy commissioner. In the said representation, they stated that they're seeking a small plot of land, Lordship.
After this representation, my lord, within a week, my lord, some officers came, my lord,
Just a moment.
and my lord,
Just a moment.
Lordship. Notice.
No. Your representation doesn't ring truth.
Lordship, even the Lordship, my lord, that
You see, I'll tell you why. You said that you had a shop opposite the deputy commissioner's office. Correct? That's your pleading. You say that you were asked to vacate. And then you vacated.
Yes.
And then land authorities came, the revenue authorities came and gave you a plot of land. Correct?
Yes, my lord.
Are you convinced that you are saying the truth?
Yes, my lord.
Correct.
After-
Okay. No, it's okay. I'm not doubting you,
Lordship.
but I have a very bad habit. You see, this is the photograph of the office of the district commissioner at Harsingi Mari.
Lordship.
In your photograph,
My lord.
same, incidentally, the same structure is found here.
Lordship.
Correct? So it's the same place.
No, my lord, this is after vacation, my lord. Earlier, it was on the opposite side. When the notice was issued and it was required for the expansion
No,
of
no.
road, my lord, I vacated my shop, my lord. The earlier shop was vacated. It is newly established, my lord. It is newly constructed, my lord.
No,
This
no.
is the doubtful lordship.
Doubtful.
Well, instruction may be, well, they may be directed to.
No,
upon
not when
instruction.
you're occupying the, you're not settled with that.
Well, this is my pleadings, my lord. That earlier, my lord.
But the site is same.
Side is same lordship, my lord, that
Now it is at the side of the district commissioner.
Earlier also you were there.
Well, earlier it was on the opposite side, my lord. That side, my lord,
No.
was taken over by the authority for expansion of road, and already, my lord, road has been expanded. Now, subsequently, my lord, I submitted this representation to the
Road
district.
encroachment we can't permit. Just issue a notice to find out, you give a response.
lordship, my lord.
We're not protecting you. Heard Mr. M.A. Islam Learning Council for the petitioner. Also heard.
Madam, this is a case of, what is my submission in this case, madam? This is a case of promissory estoppel also, because this shop has been constructed, madam, this new shop, madam. Where, madam, I'm seeking protection, madam. This area, madam, this land has been, madam, allocated by the authorities. I have been asked to.
They could not have allocated. Just making an inquiry, let them submit.
Lordship. Maybe.
Even and my lord, that notice was issued, my lord, 3/2/2024.
Once that photograph comes up, we
Lordship.
can't help it. Also, Mr. E. Bhattacharya, Learned Standing Counsel for the Finance Department, appearing for respondent number 1. And Mr. J. Henrik, Learned Government Advocate, appearing for respondent number 2 and
2 and 3, lord.
The petitioner projects that after orders of the District Commissioner Hart Singimari to vacate the shop opposite to the said establishment, the petitioner had vacated the shop and made a representation on 5/2/2024 and 6/2/2024 for allotment of land to carry out her business. Petitioner projects that the authorities under the District Commissioner Hart Singimari, South Tharmara Mankachar, Hart Singimari, allotted a land to the petitioner where she has set up a stationery shop. And the revenue officers under the Circle Officer, Mankachar Revenue Circle, came to the establishment of the petitioner on 25/4/2024 to demolish the shop without a notice. Next paragraph. The Learned Government Advocate shall obtain instructions from the District Commissioner. South Tharmara Mankachar, Hart Singimari, to inform as to whether the authorities under him have allotted the land where the petitioner is presently set up a shop after she has vacated the premises, which is covered by the eviction notice dated notice number MKC -38 public part PT public 2019, public 38, dated 3/2/2024. Issued by the circle officer, Mankacha Revenue Circle. We are listing it on Friday.
It's Friday. Friday, my lord. On 7, my lord, there is a election, lordship.
You can get this information, they will be knowing.
Lordship.
If they have.
I will try, I will try.
Just on Friday. Photograph of the site produced by the Illinois Council for the petition is kept as a part of the film.
Item 25 with 26.
Made with the lordship. Lordship may be pleased to take 26 as well.
Pardon me?
Item number 26.
26.
Lordship. Lordship, they had the.
Just one.
Lordship.
In such matters, orders were passed.
Lordship.
Similar matters have been disposed of. Mr. Taluga, are you aware?
No, Lordship, I am not aware of. However, my lord, they are seeking some more time. Asking for some more time.
No, these IDs are not being created.
IDs are there.
Therefore,
but
they can't get allotment. I think we have disposed of such
Then
vehicles.
the BTC will be required.
I'm there, but I have no idea about that.
No.
My instruction is that ID will be created by the Director of Food and Civil Supply, Commonwealth.
But their allegation is that those IDs are there, but they are not released.
No, that has not been created. IDs have been given but not created in the portal. So that's right.
No, Lordship, another thing, the Assistant Director has forwarded the proposal to the CHD, Chief Head of the Department, Lordship, PTC Kokrajhar, Lordship. There are available ID with the department. They can utilize this ID. This is the only problem. Lordship, we have annexed.
I am not following you.
Lordship, there are vacant ID with the Assistant Director of Food Civil Supply, Lordship. As per
Vacant ID.
Lordship. Lordship, kindly have a look on page 61, Lordship.
51.
61, Lordship.
61 of the second petition.
Of the second petition. Here, Lordship will get the name of the petitioner.
Just a second.
Lordship.
What is vacant ID? I did not get it.
Lordship, there are already vacant ID because of resignation of the earlier dealer, Lordship.
No, that can't be done.
Lordship.
That will create difficulties. You have got POS machines, no?
No.
They've given you POS machines,
No,
no?
Lordship, because of not having the dealer ID, Lordship. But Lordship, these are priority sector,
They
Lordship.
have the instruction.
Mr. Bala, you got it. You see, we are not saying how to do it. But if they are the PDS shops, they have to create an ID and give them the point of sale machines, because otherwise they are not getting things and
My instruction is the new ID should be created and that had to be created by the Director of Food and Civil Supply. Then only will be. That is the instruction. ID will be created by the Director, Food and Civil Supply. Lordship. Lordship.
That I don't know, that I don't know, whether it can be done.
I have the written instruction of the. I can let it go. Okay, I have it.
No, good enough. Okay. No issue.
From N Kolita. N Kolita.
Gao Panchayat from Vaishnav.
Council
Chief head of the department.
Council head of department.
Yes,
Council head of department.
Yeah, 27, 28 before.
Lordship, Lordship was released to protect us. That protection may continue, Lordship. Otherwise, we may. Lordship. First on 26/6/2023. Lordship, same thing, Lordship. Lordship, as your Lordship.
Twenty-five to Kora nine, 25 to put it to disclose.
Lordship, may I pray on Friday, Lordship? Friday, Lordship, time. Oblige. Oblige.
25.
Highly obliged.